30, Your Lordship. Lordship, kindly this matter may be taken up on 16th of June, Your Lordship. Senior counsel is not available today, Lordship. 28 to 30. 30.
Supplementary.
Yes, Your Lordship.
Okay. Your fault.
I'm appearing for respondent number 4, D. Senapati.
Okay. You are Mr.
S.K. Saha.
Land Counsel for the respondent number.
Lordship, I'm on behalf of the petitioner, Lordship.
You are for the petitioner.
Yes, Your Lordship.
Your name is there.
No, Your Lordship, I'm appearing on behalf of MSN Havelia, Your Lordship.
Appearing on behalf of Mr.
MSN Havelia.
MS Land Counsel for Avelia, Land Counsel for the petitioner. Praise for adjournment of the matter and to be fixed on
16th of June, Your Lordship.
16th of June. To which Mr.
I'm D. Senapati, appearing for respondent number 4.
Land Counsel for the respondent number 4 and
Yes,
Miss, your first state respondent.
yes, Your Lordship.
Okay. He is also present. He is grateful. List his matter on
16th of June, Your
16th
Lordship.
of June. Okay.
Deeply appreciated.
May I, Your Lordship? I beg to mention item number 26, Your Lordship. Here we have not filed our counter affidavit, so at least 2 weeks time may be given.
So who is for the petition?
Yes,
Yes.
for the petition, I am for the petition matter.
Yes.
In fact, today is fixed for consideration of the interpreter matter.
No.
So affidavit is not forthcoming matter. But their prayer may be accepted matter. The matter will fix after matter 10 days matter. And matter in the meantime, let them file the affidavit matter. And next step, we need to fix for matter consideration of the interpreter matter.
Okay. Miss Rintu Sir, Mr. Rintu Sir, the land counsel for the petitioner is present. Miss. Appearing on behalf of the first respondent. Praise for
2 weeks time, Your Lordship.
Father. Right. For filing. You have received, not yet received instruction.
Yes, Your Lordship.
So Mr. C is yet to receive instruction to file affidavit and praise for some more time. The respondent is granted for the 10 weeks, no, sorry, 10 days for filing affidavit in opposition. List this matter after 10 days. Okay.
In the meantime, matter, let them.
On which date,
next date, matter.
on which date the interim prayers shall be considered.
Yes, Your Lordship.
May I proceed also?
Yes.
I beg to like item number 22. On behalf of the Lady Council, Subu Koyang, respondent side, made this matter after 2 weeks. I took the concern of the petitioner side also.
For the real matter, state is yet to file the affidavit also matter.
Yes, in the
In the
meanwhile,
meantime, let the state file the affidavit matter.
Okay. Mr.
M. Bagara.
Made a prayer on behalf of Mr. Subu Koyang, land counsel for the respondent number. 4.
Oh, not exactly know the respondent, but only the behalf of the Subu Koyang, Lady Council.
Okay. You have filed affidavit?
Yes, in between the.
No, you have filed affidavit?
No, not yet, Your Honor.
Great.
In the meanwhile,
Appearing on
my
behalf
lord.
of Mr. Subu Koyang. Praise for Father, how much time you say?
After 2 weeks,
Father 2 is time to file affidavit. The office note also indicate that the state respondent is also yet to file affidavit in opposition. In view of the above, the case stand adjourned. In view of the above and as prayed for, list this matter after 2 weeks. Mr. Rintu Sarkalan, counsel for petitioner is also present. Okay.
much obliged.
Your Lordship, I would like to mention item number 16. I have also taken consent from the opposite party. Your Lordship, the matter may be adjourned for today and listed after 3 weeks because we need time to seek further instructions
You are for?
for the petitioners.
You are Miss?
K. Chotan.
Lana counsel for the petitioner is present. The service report upon the respondents as Still awaited. In view of the above, list this matter after
3 weeks.
3 weeks. Okay.
of lunch.
Mayor, Your Lordship.
Yes.
Lordship, I beg to mention item number 11. Your Lordship, I have taken consent from the other party. I am representing respondent number 4, private respondent. Lordship, today we were supposed to file affidavit in opposition, but since the leading counsel is out of station for some time now, and he will be returning by tonight. Lordship, I pray for 2 weeks' time.
Your correspondent number,
4, private respondent.
Mr.
N. Hari.
County Council appearing on behalf of respondent number 5, praise for adjournment of the matter. So with the consent of the County Council for the petitioner, praise for adjournment of the matter for
2 weeks.
2 weeks. Prayer is allowed. List this matter after 2 weeks. Okay.
Obliged.
Hello, in item 1 and 2, we were supposed to take instruction on the additional affidavit filed by the petitioners, my lord. My lord, we just received a WT message from the respondent saying that the matter is under active consideration. With regard to the reply to the additional affidavit, my lord, filed by the petitioner. My lord, so, my lord, if some more time may be granted, because there is an additional affidavit filed by the petitioners. We have fixed that.
2 weeks. Mr.
Ari.
County Council for the petitioner. Please present.
Your Lordship, item number 1, referring. Item number 1,
Yes, you are for?
I'm referring from petitioner side.
You are for?
Petitioner side.
Petitioner?
Yes.
Item number
Item
1.
number 1.
I am for item number 2.
Okay. Okay, you are Mr.
Tito, Tabato.
Please, of Land Council for the petitioner in double petition. Land Council for the petitioner in double petition 464 2023 and Mr. Okay. In WPC 320, present. Mr. Nino Ratan, Land Additional Advocate General for the state respondent. You have received or not yet received this parawise?
Not yet received
Okay.
parawise reply to the additional affidavit. my lord.
Okay. Some is, in a praise for father, how much time you said?
2 weeks time, my lord.
Father, 2 weeks time to file affidavit in opposition to the additional affidavit filed by the petitioner. In both the petition?
No, in item 2.
Okay. In item 2,
Yes, my lord.
in 32023, and in item 1?
Item 1, that is different, my lord. We have already filed our affidavit.
Okay. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 2
2 weeks.
2 weeks. Okay.
My lord, interim is there, interim may be
There
continued.
is in both the case.
Yes.
The interim order was also modified.
Yes, my lord.
Yes.
The modified interim order may continue.
Meanwhile, the modified interim order passed address will continue till the next returnable date.
But matter may be fixed for hearing on next date.
The admission.
Has it been admitted? Not yet, I think. Okay.
Obliged.
Yes, Your Lordship, I'm appearing on behalf of T. Garam, Raja Garam. Petitioner? Yes, Lordship. He asked me to seek adjournment for this matter for a 1 week. Adjournment for 1 week? Yes, sir. Mr. Ivan. Ivan. Appearing on behalf of Raja Garam. Appearing on behalf of Mr. Raja Garam, Land Council for the petitioner. Mr. Tagum, he is seeking adjournment. Item 3, he is seeking adjournment. Praise for adjournment of the matter for
1 week.
1 week, to which to which the Lana Council for the respondent has no objection. Accordingly, the prayer is allowed. List this matter after a week. Okay. Hello.
Number 4 and 5.
Yes. 4 and 5. Yes, my lord, in this case, the state government till now has not filed any affidavit in opposition as such. There are two similar writ petitions, substantively similar relief with a little variation. Now, in WPC 24 of 2024, the state government has not filed any affidavit so far.
Not yet.
Not yet. The
Okay.
proper affidavit in opposition has not been filed. They have only filed an affidavit stating that the Rule 15 interpretation, which we had given, according to them, the kind of interpretation they have given to the Rule 15, that doesn't go against us. So in view of that very clarification, we are no longer pressing the relief, challenging the rule itself.
Okay.
So that part is over. But the difficulty is there is no proper affidavit in opposition on record. Now, we do not know whether the state wants to file affidavit or not. If the state doesn't want to file any affidavit in opposition, then very well the matter may come up for admission hearing. I am coming very well on 7th of April. On 8th of April, my lord may fix up these cases. If they want to file any affidavit in opposition at all, then in that case, they should do it before that.
So the state is filing.
Manushree, in item number 5, we have filed Manushree.
But
You have filed-
24.
Not yet.
24. In this, Mr. S. Tapin, he's appearing, so he'll be,
In item 4,
yeah,
this Tapin is appearing.
yes, Manushree.
And in 5, you are appearing.
No, in 4 and 5, he's appearing.
Or he is appearing.
Yes.
So whether the state will file the affidavit.
Let it be on 8th of April, my lord. Let it be listed. So before that, they can file their affidavit in opposition in WPC 24. Because there are lots of new facts in WPC 24.
Mr. Kibar. Non-senior counsel. Assisted by Mr. Tito, non-counsel for the petition. So you are not appearing otherwise here in this case, in for the case, item 4 and 5.
No, we are for the government, for respondent 1 to 4.
Okay, 1 to 4
Yes.
by Tapin. 1 to 4, you are for 1 to 4.
We are for the government, so I'm
Okay.
assisting Mr. S. Tapin.
Okay, you are assisting, okay.
Yes.
Miss, so you are praying for some more time to
Yes.
file affidavit, okay. Miss
K1,
K1, appearing on behalf of the state respondent, number 1 to 4. Praise for Father. How much time it will be? 2 weeks.
Because, my lord,
Time to
if
file
it is fixed on 8th of April, they are getting more than 3 weeks.
It will be more than 3 weeks.
They are getting more than 3 weeks, so let
Okay,
it be 2
okay,
weeks.
Praise for Father, 3 weeks time to file affidavit now.
Let it be not 2 weeks. 2 weeks for filing affidavit in opposition by the government, and matter may come up on 8th of April.
Okay, 2 weeks. The prayer is allowed. Please pray for come up. List this matter on
8th of April, 8th.
8 April. Okay. Our group. Are you appearing on? item
Appearing for respondent 2, 3, and 5, your lordship.
I'm for 6, Your Lordship. We have not filed our counter affidavit, Your Lordship.
Your lordship, what happened this matter, your lordship, we have raised the issue of mutability, your lordship, being there is a adequate remedy, your lordship. So if that can be considered first, your lordship. In this matter, your lordship, we have Power Grid has filed the affidavit wherein we have raised the question of mutability as there is adequate remedy under the Indian Telegraph Act.
You have already filed.
Yes, your lordship, we already filed.
No one appears on behalf of the petitioner on court. Ms. Pangu, for you are for respondent one?
Yeah, I'm for respondent number 6, your lordship.
Who is for the respondent number 1, 2?
But I am for the respondent number 1.
Okay, sorry.
So, my lord, our affidavit may not be required because the
Affidavit not required. Then it's DSTI appears on behalf of respondent number 1. 1 is Mr. Kadir.
One only.
1.
10 minutes remaining.
And you are for?
I'm for petitioner, my lord. My lord,
Sorry.
in this matter,
Okay.
petition was supposed to be amended by the petitioner.
Is it?
Yes. So we may be allowed to amend the
Then leave
petition.
that one, the petition is. So you want to amend the petition?
Yes, ma'am.
Earlier granted. You made a prayer earlier.
No, my lord, today itself I am making the prayer.
Your
They
lordship,
are
4
saying
and 6,
amending
your
the
lordship.
petition.
There has been no prayer earlier about this.
Okay, now they are praying for amendment of the petition. Yes. Okay. Mr.
R. Ingon. I'm on behalf of SMO.
Okay, appearing on behalf of Sunil Mo, Direct Counsel for the petitioner. What amendment?
My lord, there are certain notifications which we need to file.
Incorporated.
That was not annexed in the petition.
Some is that. It's a subsequent notification or the.
As well as subsequent notification, earlier notification also, my lord. My lord, in our pleading also, we need to amend some.
Some is. There are certain. Notification issued by
Government of Arunachal Pradesh.
the government. Subsequently also.
Yes, subsequently
filing
also, and
also.
earlier also,
Okay.
already exist.
Certain documents. Which could not annex at the time of filing his writ petition and praise for allowing him to amend the writ petition by incorporating the government notification and the subsequent notification issue, and the subsequent notification issued by the government. The state respondent, huh? The Islamic Council for the respondents has no objection. Accordingly, the prayer is allowed. This matter after
2 weeks, 2 weeks.
2 weeks. Then
You'll-
their presence be recorded, huh?
Your lordship, in the event we may be allowed to reply to whatever amendment they are making,
Yeah,
your
in
lordship.
that case, that's an opportunity. In the event of. You have already filed, not yet.
We already filed, your lordship, for
Okay.
respondent number 2, 3, and 5, we already filed our affidavit wherein we have raised also the question of maintainability of the writ petition.
Not yet filed.
No, we already filed, your
Then,
lordship. On the last, your lordship may kindly peruse the last order, it has been reflected.
okay, this is regarding maintainability of it.
Yes, Lord. No,
Nothing.
we counter affidavit along with maintainability, we have raised itself in the same affidavit, your lordship.
Hmm?
We have filed our counter affidavit where we have raised also the question of maintainability in it.
Okay, you file first, then serve copy. Okay. Okay.
Lordship, our
Please
present,
announce the 2 weeks,
our
huh?
present may be recorded, your lordship.
Yeah, you recorded.
All right, your lordship.
Yes, and then they are present only in the beginning. Okay. Yes.
Your lordship, I'm deeply sorry for the interruption, your lordship, but I want to mention item number 3. Just before it was mentioned by one of my colleagues, your lordship. So in item number 3, we have missed out some point, your lordship. In item number 3, for the petitioner, we're going to file a rejoinder. So for that, Your Lordship, we need some more time, like 3 weeks, Your Lordship.
In item number 3, you are for the petitioner.
Yes, Your Lordship.
Whether petitioner was present earlier. Okay, rejoin the respondent has already filed affidavit.
Yes, Your Lordship. They have already filed affidavit in opposition, so we will file the rejoinder.
Okay, in that case then. Right. Miss, you are Miss?
B. Mema, on behalf of Taja Garam,
Petitioner, praise for how much time?
3 weeks, Your Lordship.
3 weeks to file affidavit in reply to the affidavit so filed by the respondent, the prayer allowed, huh? And then Tabat, prayer allowed, huh? This Tabat presence. Okay, Mr. Tabat, counsel for that. The standing counsel education department is present. It's grateful comment list is matter after 3 weeks, huh? Okay.
Deeply obliged, Your Lordship.
Yes. 7. Item 7.
In item 7, my lord, the state government and the my lord, central government is to file affidavit, my lord.
My lord, some more time may be granted, my lord. I appear for 1, 2, and 3. 1, 2, and 3.
Mr. R. Kirkland, counsel for the petitioner is present. Mr. Nino Ratan, Lion petitioner is appearing on behalf of the state respondent. Wait for how much time?
My lord, it is 2 weeks time, my lord.
2 weeks.
Yes, ma'am.
Time for filing affidavit in opposition. Mr. Marshall, you have also not yet filed.
No. For respondent number 5, 4 and 5.
Okay. Appearing on behalf of respondent 4 and 5 made a similar prayer. Accordingly, the prayer is allowed. This is matter after 3 weeks. Okay.
Okay.
Hello.
by the registered body within 7 days from today. The least is matter after 3 weeks.
Yeah, Lordship. Lordship, I'm for the petitioner. Lordship, it's been for more than 4 months. I've started to notice again respondent number 4. It's not received yet.
Not yet received.
Yes.
What to do? You take fresh steps.
Uh, Lordship, I pray it's considered it's assumed, it's presumed that it's already served. So I pray for final argument.
Respondent number 4.
It's Gyati Anda.
What about respondent number 5?
Respondent number 5, Lordship, it's considered already ex parte. In earlier, it's considered only ex parte. Respondent number 5.
By which order? There is no record event that you have taken steps upon the respondent number 5.
Yes. Lordship, I guess order dated 13/1/24.
13/1,
Yes. Oh, sorry, 3/1/31.
2025.
24.
No. By this order, you were asked to take steps for service of notice upon respondent number 4 and 5 by register post with AD, as well as by usual process within a week from that day. Have you taken steps? This is only directing you to take steps. This is the first day when the matter was listed. Thereafter, you did not take steps.
Lordship, on 19 January 2024, I have taken step against respondent number 4 and 5.
January.
Yes.
Mr.
SMC.
S.
MC.
Would you follow? The reading of Learned Counsel for the petition is present and submits that he has taken steps upon the respondent number 4 and 5. Respondent number, however, no one represents the respondent number 5 despite the receipt of the notice. And but respondent number 4, you have to ensure that it has reached respondent number 4. Respondent number 5 is fine, has received the notice, but then 4 has not yet received, it appears.
Yes, Lordship. Respondent number 4.
Service report not yet received. So what do we do? We take final, take press steps
Right, sir.
in view of the office note dated 17/3/2025. The Learned Counsel for the petitioner prays for allowing him to take press steps upon the respondent number 4. The prayer is allowed. Steps by a registered post with AD within a week from today. So, this one, Learned Counsel for the respondent number
1, 2,
and the government advocate appears on behalf of the respondent number 1 to 3. List this matter after 3 weeks. Okay.
If may I intervene, I apologize, Your Lordship. In item number 6, Your Lordship, if I can get a fixed date, Your Lordship.
What?
In item number 6, if I can pray for a fixed date, Your Lordship, being outstation
Pray
counsel.
for?
Fixed date. Item number 6. I've taken consent from the petitioner as per his convenience is on this 8th of April, Your Lordship.
Item number 6.
Yes, Your Lordship.
What you want there?
Just a fixed date, Your Lordship.
Hmm?
Fixed date, fixed date.
Fix it.
Yes, Your Lordship.
When?
On the 8th of April.
No, where is the other counsel for the other side?
I've taken convenient, consent is, convenient date is on the 8th of April, Your Lordship.
What is the order? That's 4 weeks. So when?
4 weeks, Your Lordship. If you can be 4 weeks, any date, Your Lordship.
Hmm?
Can have on 23rd after Puja vacation, Your Lordship.
When do you want after Puja vacation?
23rd,
23rd,
April. That is
20?
after Holy,
20?
23rd.
23rd probably is DB, I think.
DB.
Wednesday DB. No?
22nd can be.
Okay, 20. Instead of 4 weeks, let's pray for by the Learned Counsel for a party this matter on 22nd April.
Ali oblige, Your Lordship.
My lord, in item 15, my lord, the pleadings have been completed, my lord. And matter may be fixed for hearing, my lord. We have also filed an additional affidavit on 8th of March, bringing in some facts which has not been disclosed before this honorable court by the respondents. So matter may be fixed for hearing, my lord.
Item 15.
My lord, it's a contempt case, my lord. Since the pleading is completed, my lord, the only thing which need to be seen is here whether the alleged contender has deliberately violated that order of this honorable court or not. There is nothing to be pleaded, my lord.
My lord, certain facts were not disclosed before this court, which we have
That is
found out.
irrelevant, my lord, whether disclosing or not. The fact here is that, my lord, whether the order was violated or not.
My lord, if certain facts were not disclosed, the delivery of justice will not be complete. That's why we filed an additional affidavit. So this
They
matter
filed
will-
their affidavit. I have filed my affidavit, they have filed a reply, I have got it, my lord. Pleadings
We
are
have also-
completed, my lord.
Okay, can we fix for the now hearing?
No, my lord, it's a contempt case, my lord, it can be heard today, simple, my lord. Pleadings are complete, my lord.
No, my lord, it needs a detailed hearing, my lord. It will be, let this matter may be fixed on 22nd of April, my lord. Because certain facts have not been disclosed, which we have brought through the additional affidavit, my lord. And they need to answer on that.
Already filed reply affidavit also.
Yes, my
They
lord, we
have-
have filed my affidavit and we have filed an additional affidavit on 8th of March.
18th. No, when? 8th of March.
8th of March, my lord, additional affidavit.
Okay, additional. Have you received the additional affidavit?
Yes, my
Okay,
lord, yes, my lord, yes. I've gone through it, my lord. There is nothing in the reply, my lord. These are all facts, my lord.
By the way, what was the direction?
My lord, the direction was to proceed with the complaint filed by the petitioner in accordance with law, my lord. And that is at page 15
My
and
lord,
16.
I'll just, my lord, may come to the contempt petition, my lord.
That's page 15,
What-
my lord.
Let us see, what was the.
Page number 15. Page 15 of the contempt petition, my lord.
Yeah.
The relevant paragraph would be, my lord, page number 17.
Well, page 16 down below, my lord.
16 and the 17. May I read it, my lord?
Yes.
In view of the above, and having regard to the nature of the prayer made by the petitioner, in this petition, I hereby deem it appropriate to dispose this writ petition with a direction to the respondent number 4. Superintendent of Police, SIC, near Information Commissioner, ESS, Sector so-and-so, to act upon the FIR, first FIR, dated so-and-so, lodged by the petition in accordance with law. This is the direction which was given. To proceed with the FIR dated so-and-so, to 29/2/2022, lodged by the petition in accordance with law.
Okay, then what is the compliance?
Now, my lord, may I kindly turn to my reply, my lord. My reply, my lord.
Your reply.
Yes, my lord. Madam, can you turn to page 16? Page 16 of my reply, my lord.
Yes.
16, my lord, NH 1. My lord, can you see the date?
Just a minute, sir. Who is this contempt now there?
He's the SP, SIC. He's an honest IPS officer, my lord.
Okay. Yes.
Page 16, my lord.
Page 16.
Yes. 13/1/2023, my lord.
Hmm?
13/1/2023.
Yes.
Now, my lord, coming back to that order, my lord, the order which was passed, it was passed on 12/7/2023, my lord. Page 16 of that contempt of petition.
Yes, 12/7.
12/7/2023. Now come, and then the allegation was that, my lord, I have not adhered to the, and deliberately not adhered to the order of this honorable court, my lord. And it was passed on 12/7/2023. Now, my lord, may come to my reply, my lord. 13/1/2023.
Prior to
Yes,
the order.
because the complaint was filed in 2022, my lord. Prior to that, my lord, I've already taken the action, my lord.
Just a minute, sir. This is the complaint.
No,
The 16 is complaint.
no, my lord. My lord is well aware, my lord. This
No, what
pertains,
is this? Then 16 is complaint,
no, my lord, no, my lord.
page 16.
This is a
Yes.
forwarding letter, my lord.
Mm.
My lord is well aware, my lord.
Okay.
Since it is a PCA case, my lord, before inquiring into any matter as regard to the government servant, my lord, we have to take approval from the government and under section 17A of the PC Act. So this is the action which we have taken, my lord, the SP has taken. The moment the complaint was received, we have written to the competent authority asking them to give us the approval for inquiry, my lord. Because I cannot directly inquire, my lord, because there is an embargo under 17A of the PC Act. So I
My
have
lord,
taken the approval, my lord.
This page 16 is approval,
Yes, no, I'm seeking approval, my lord,
seeking approval
from the government, my lord.
just a minute, let us see the letter. Is a complaint and so.
18, my lord, is the type copy, my lord. Page 18.
Hmm?
Page 18 is the type of copy, my lord. May I read it, my lord?
Yes.
And enclosed is a complaint which alleged irregularities in the appointment of MTS by the Education Department through DDSE Inkyong. The complaint is also enclosed a pen drive where a communication by which and DDC Inkyong is claimed to have taken place, alleging the same, hereby alleging an involvement of senior officers is also alleged. Considering the gravity of the matter, permission for registration of a regular case may be kindly granted. This is the action which I have taken. Now, next page, my lord. Page 19, my lord.
Yes.
Page 19 is the approval which I received, my lord, which is on 12 July 2023. This is the approval from the government.
On the same day.
Yes, on the same day when the order was passed, my lord. But before the order was passed, my lord, I have already taken action, my lord. I have already written to the government, to the competent authority, to grant us permission for the registration of the regular case, my lord. Now, on the same day when the direction was passed by the honorable court,
What is this? This is dated.
this is the approval.
12 July or 11 July?
Yes, my lord.
No, which one is correct?
12 July, 12/7.
Below sign is 11 July.
No, my lord. Top above, my lord.
How it is possible? Prepare on 12 and sign on 11?
No, it is signed on the 11, but it was already 12 July.
No, that is why I'm saying.
Hmm.
Prepare on 12. How the sign can be on 11th?
It was
Prepare on 11, sign can be 12, 13. Thereafter, but prepare done on 12. It appears.
whatsoever, my lord. My lord, can you see
Okay.
the SIC in the left side, my lord?
Yes.
Our office received it on 12/7. On the same day when the order was passed by this honorable court, my lord. That was the day when we had that approval, my lord, from the competent authority, my lord.
Okay, this was done.
Yes, my lord. Now, my lord, kindly come to page 13th. 13.
1-3.
Page 21.
21.
Yes, my lord. 21, my lord. 13/7. My lord will kindly appreciate that, my lord. The direction of this honorable court was passed on 12/7/2023. And this order, approval was
13.
issued on 12.
This is what? This order is?
This is following the matter is endorsed to Inspector Kamwa. So and so. And the matter was already given to one of the officers for inquiry, my lord. It was engaged for inquiry to one of the officers, my lord. The next day when this order was passed, my lord. In fact, my lord, on the 1st of, in the January itself, we have taken the action, my lord. And now, my lord, can we come to page 20?
Just a minute. What is this letter? What this letter says? Order 13-7
Is the
passed
endorsement
by-
order, my lord.
This is the alleged contempt order. This SP is.
Yes, yes, yes. He is endorsed because he's the SP, my lord. He has endorsed one of his inspector to inquiry about the matter, my lord.
Okay, so thereafter,
Thereafter, my lord, page 22. My lord, may kindly see down below. 18/7/2023.
is, what is this?
This is the statement under 161.
Statement
Yes, my lord.
of the
Complainant, my lord.
complainant.
Yes, my lord.
The informant here, the petitioner.
Yes, my lord.
When this was recorded?
18/7.
18/7.
Yes.
Okay, subsequent after passing this order.
Yes, order was passed on 12th.
Hmm.
It was taken on 18/7. 5 days.
This was recorded by the IO of the.
Yes, my lord. Because I was engaged on 13th.
13 July.
Yes, my lord.
IO was
Hmm.
directed to conduct preliminary inquiry.
Exactly, my
And
lord.
this is the statement under of the informant
Yes, my lord.
in the process of conducting preliminary inquiry.
Yes, my lord.
Okay.
Now, my lord, the 23 is the collection memo. Now, during the course of investigation, my lord, I mean the inquiry, my lord may see the date and seizure. 18/7 on the same day, my
On the
lord.
same day.
Yes. 12:30 hours, my lord.
So he himself has signed on 18.
Yes, he himself was signed. And what was seized, my lord? Particulars and article collected. One blazer, serial number 5, my lord. Particulars of article collected. One blazer blade 16 GB pen drive. Red oblique black in color, containing voice clip in between Sri so and so versus so and so of 28.7 MB, 30.46 minutes, reportedly recorded through the former mobile on 3/5/2021 at so and so, and signed by
The informant.
yes, the informant. And 24 would be, my lord, the 25 is the type of copy, my lord. Now the complainant so and so. So he appeared before the examination by inquiry officer and his statement recorded, the pen drive so and so have been taken. And this is the record. Now, my lord.
So this way, according to you, this was.
My lord, the order of this honorable court directing the contender to take action in accordance with law was passed on 12/7/2023.
Yes, what remains?
What remains, my lord?
Just-
This is what I'm saying.
What remains?
My lord,
According
in the additional affidavit, we have stated that certain documents which were there were not produced, my lord. So in that context, my lord, I may be allowed to put those documents which I filed before this honorable court through the additional affidavit to the IO
No.
on a fixed date, my lord.
No. The document, because as
Because
per the
there were-
direction,
and one paragraph they stated there were no records, but in my additional affidavit, there were records to show
the
that
respondent
these
was
persons were
directed to
illegal.
act, the respondent was directed to act upon the FIR filed by you
Yes, my lord.
in accordance with law.
Yes, my lord.
And it appears that it was proceeded in accordance with law only. Before
Yes,
the
ma'am.
Action was taken.
prior
my
to you
lord-
approach the court, they have
My lord,
already
if-
initiated action. But
Yes,
then,
my
it's,
lord.
of course, now whether you submit the documents or material, whatever may be, that is in the process only. But then
Yes, my lord. So
the respondent or the alleged contender has already initiated
yes,
and
my lord. but-
acted in accordance with law, it appears. What
Yes, my lord.
remains?
My lord, I was offered bribe to withdraw the complaint by the accused persons, my lord. That I wanted to bring before this honorable
Then
court.
why don't you file FIR thereafter?
Yes,
Against
my
that?
lord. So
Against accused, that will be a different cause of
Different
action.
corporation.
because we have already submitted the evidence before the IO, my lord, and the subsequent additional affidavit
No,
where we have stated-
you file subsequent
Yes,
application for
because
the
we got hold
subsequent
of those
act.
documents later on, my lord. That's why we've had to file an additional affidavit. So we may be allowed to approach the
No,
IO
additional affidavit, what for additional affidavit?
because, my lord, there were illegal appointments of 5 persons, my lord, and the IO had said that there were
That
no
is why
records.
it was, that is why the inquiry conducted and accordingly
And
your statement also
then-
recorded.
Yes, my lord. But since
what-
I found further
Thereafter what
documents,
happened? Just a minute, thereafter what happened by the way?
Now that inquiry is going
After
on.
inquiry, the
It is going
inquiry
on, my
report
lord.
submitted?
Yes, my lord. And then my lord, my learned friend is, he's not coming to the court with a clearance. Why? Because, my lord, there is already a PL which is pending regarding this case.
No, because here, somewhere, the SP has directed the IO
Yes,
to
my lord.
conduct inquiry and submit report.
Yes, my lord.
Whether the IO has submitted report,
Yes, my lord. Now the inquiry is going on now.
inquiry is going on.
It is not yet
Till now.
complete. Yes, and since different cases pending regarding the same matter, my lord. My lord, what I'm harping upon is, my lord, see, it's a contempt case, my lord, and I'm an honest officer, my lord. There was a direction by this honorable court on 12/7/2023, my lord, to act according to this law, my lord. But before that, the moment the complaint was received, my lord, I've already initiated the action, my lord, by writing to the government for giving me that approval, my lord, on January, my lord, before this order was passed, my lord. And after this order was passed, I have diligently taken all the actions, my lord. But they say that I have not taken
What
any
is your,
action.
this additional affidavit?
my lord, additional affidavit is regard to the fact that the IO stated that there were no records, my lord, for appointment of certain persons, my lord. But in this IO, we have stated that there are records and we have annexed those letters, my lord. My lord, may come to paragraph 1. May I read it, my lord?
Yes.
The petitioner respectfully submit that additional affidavit for purpose of placing record of illegally appointed multitasking staff in the education department of Upper Siang. The necessity of filing instant affidavit arises from the fact that on 23/1/25, the in charge director elementary education, in reply to SIC, now Anti-Corruption Bureau, letter dated 13/7/23, my lord, which my friend has just now read, stated that there is no record available regarding appointment of MTS, namely Miss Nilu Sitek and such, 5 persons, my lord. My lord, I say that this is a false information in paragraph 2, stating that director in his letter dated 24/1/25, that is annexure 2, sent by the DDC Inkyong, stated that these persons were promoted without conducting any DPC at district level. And at paragraph 3, we have stated that on 24/1/25, the same deputy director of school Inkyong has stated that there is no service record of these 2 persons, Ase Tayang and Nilu Sitek. And this is also a false information, as DDC himself, Inkyong himself, issued a posting order on 22/2/21, which we have annexed at annexure 3. Well, these facts have not been disclosed, my lord, and it has to be taken care of by the IO. But in his report, it has not come up. So there is an attempt to
See,
shift.
My lord,
person.
this is-
see,
simple objection.
your petition, your contempt petition is against the SP.
Yes.
Yes.
SP has already directed endorsing the IO to carry on the inquiry and submit
Yes,
report.
ma'am.
And then
Yes,
during the
ma'am.
inquiry, what had happened, what the IO used to do, that is different issue.
Yes, my lord.
Yes,
That is
ma'am.
different issue.
But I just
And then
want to
it is also a duty on your part to provide all information, and then if there is any material to produce, because it appears that there is a seizure memo also. Certain
Yes, ma'am.
documents, whatever you could produce, you open for you to produce it before the eye of the case, to
So-
reveal
so-
or to give a statement,
Since this matter was
giving all information to the IO.
before
But that is not, the role of the IO is again different from the SP. SP has already directed.
Yes, ma'am.
So what remains against SP?
So I
Can
just
you want the SP to investigate or inquire into
well, at least
by himself?
these documents may be taken into account during the
So
investigation.
that
my
is
lord.
different issue what
my
I'm
lord.
saying. That is different issue.
Yes, my lord.
The information, if the IO is not taking, it's your, because you are informant, you can give further information.
Yes,
By
my lord.
provide further information or further materials if there is available.
Yes, ma'am. But since the matter was pending here, I brought this to the notice of the court, my lord, how it is functioning, my lord.
Okay.
Well, at least
Before my-
an observation may be made that I may be allowed to proceed against him in respect of the affidavit that I filed
Well,
before
this
the
is a contempt case, my lord. Whether I have, the container is condemned or
But
not, my lord, that has to be seen, my lord.
just an observation for ends of justice, my lord.
What did you say?
For the ends of justice, my lord, the additional affidavit that I have filed, that I may be allowed to place it before the IO, my lord. That observation may be there, my lord. Not a direction, just an observation.
Okay, additional affidavit that you filed before this court.
Yes, my lord.
You want that,
Yes.
that additional affidavit to,
Taken into account by the IO, my lord.
okay, to allow you
That
to
observation.
present it before the IO.
Yes,
No,
my lord.
that would, let it,
How do we interfere with the investigation of the case?
My lord, it is not an interference, my lord, just an observation that
No,
No, man.
How do we give such kind of a direction?
He always says this, right, man?
The IO is the best person to investigate the case.
I am not seeking any direction, my lord. I am seeking just an observation that I have filed an affidavit
Okay.
here.
Oh, that
disclosing all
observation
the-
you want? Okay,
Yes,
in the
that
order. Okay.
one that it may be placed before the IO.
That whether you, that can be placed or not, we cannot say. So
Yes.
this matter may be accepted by
My
IO
lord,
or that may not be accepted.
Observation that I have the
How in the contempt case we can make such direction or such observation?
not a direction, my lord, just an observation that I have the liberty to approach.
You always have the liberty, man.
Well, if that because there is a persistent attempt to shield this person, my lord. Because I have been offered bribe to withdraw the case, and these facts have not been
No.
taken into account.
Against that, have you filed complaint or another FIR against the person who has approached you, who has tried to bribe you?
My lord, I have disclosed it before the IO. The IO is to take action, my lord. I have given the voice clips, my lord.
No,
And
you can file FIR, another FIR.
Yes, my
IO
lord.
suo motu may not be able to,
Yes, my lord.
because that is different case, different cause of action. Isn't
Yes,
it?
my lord. Yes, my lord. Only this observation that I had filed an additional affidavit bringing into records which were not disclosed before this honorable court, nor in the that may be placed, my lord, by me before the IO.
Okay. Mr.
M. Khatoniar, my lord.
M.
Khatoniar.
Khatoni. Then counsel for that. This is item
15, my lord.
Khatoni, counsel for the petition. I've also heard Mr. Opada, Lanet Special PP, SIC.
No, my lord.
Here,
It's a contempt case, my lord.
okay. Appearing online counsel. So the respondent,
The sole respondent, my lord.
Sole respondent. Subpara. This is an application filed under Article 215 of the Constitution of India, read with Section 12 of the Contempt of Court Act 1971 and Rule 9 of the Contempt of Court within bracket Guwahati High Court bracket close rules 1977 for non-compliance of the order dated 12/7/2023 passed by this court in WPC 228/2023. The direction of this court reads, the direction of this court on 12/7/2024 read as under. That is last para. In view of the above and having regards to the nature of the prayer made by the petitioner in this petition, I hereby deem it appropriate to dispose of this writ petition with a direction to the respondent number 4, which Superintendent of Police SIC, near Information Commission Office, ESS Sector, Itanagar, to act upon the first information report within bracket FIR dated 29/12/2022, lodged by the petitioner in accordance with law. So his allegation was that the SP was not
SV has not taken any action.
taking any action against on the FIR
Yes, my lord.
submitted by him.
Yes, my lord.
Okay.
My lord, if
Okay.
allegation, my lord, in paragraph 13 of his,
Allegation.
yes, my lord. 12 and 13, my lord. May I read it, my lord? Therefore, file WPC number so and so praying for mandamus of directing respondent for registering a case against and twisted investigation. This honorable court by order that so and so issued notice to the respondent. Thereafter, receiving the response from the respondent, nor any affidavit in opposition was filed to contempt the event and made it the writ petition. This honorable court on 12/7/2023, after hearing the counsel for the petition as well as the government counsel, passed order directing respondent number 4 with the writ petitioner and respondent number 1 in present contempt petitioner to act upon the FIR file dated so and so by the petitioner in accordance with law. Now, the allegation is in para 13, my lord, page 9 of their contempt petitioner. The petitioner begged to state that since the respondent was duly represented by the government advocate, the order has been communicated to the respondent. The petitioner thereafter, on finding out that the respondents have not in any manner was willing to implement this honorable court's order and was delaying the matter with regard to acting upon the FIR dated so and so. Therefore, the petitioner again by communication dated so and so made to the respondent prayed for compliance of the order dated 12/7/2023 passed by WPC number so and so. The communication was received from so and so, but till today. Now, this is very
Okay,
important, my
okay.
lord. Till today,
The
no action has been initiated to even cause preliminary investigation as per law to
Okay.
register a case
Yeah,
against the
yeah,
hearing
yeah.
officers who made
The case of
whopping
the
numbers of
petitioner is
illegal.
that The copy of the said order was communicated to the respondent, Alice Contempt. A copy of the order dated 7/12. Another what? Not 7/12, 12/7, huh? Was communicated to the respondent, Alice Contempt. And also pray for compliance of the order and direction of this court. But till today, no action has been initiated to even cause preliminary investigation as per law to register a case against the hearing officials. Stop. And thus, there has been a disagreement. The respondent has disregarded the order and direction of this court. Stop. Hence this contempt petition. Okay, stop. Mr. Opada. Direct counsel for the respondent while referring to the affidavit in opposition filed on behalf of the respondent Contempt submits that. While referring to the affidavit in opposition filed by the respondent Contempt denied all allegation made against the respondent and submits that. As per the mandate of Section 17A of the PC Act 1988, when the complaint FIR dated 29/12/2022 was received the respondent by office noting dated 16/1/2023 forwarded the same to the principal secretary within bracket vigilance for approval from the competent authority. Stop. The approval under Section 17A of the PC Act 1988 was received by the respondent on 12/7/2023. And thereafter promptly this is a letter. 13/7 is this letter or what? Order. Okay, by order dated 13/7/2023. The matter was endorsed to one Inspector W. Kamua for preliminary inquiry and to submit report. Stop. And thus, The SIC within bracket VIC, which bracket close PSENQ number 11/2023 was registered in connection with the FIR dated 29/12/2022. So. The Learned Counsel for the respondent further submits that during the course of inquiry, a statement of the informant was recorded under 161 CRPC on 18/7/2023. And seizure was made. From the informant petitioner during the course of the inquiry. Wherein the informant petitioner has put his signature. And has also offended his signature, stop. The inquiry is still, the inquiry it is, Mr. Hopa, the father submits that the inquiry is still this is a preliminary inquiry only. Yes. The preliminary inquiry is still under process. And on submission of the report, the FIR will be registered in accordance with law. Sorry. Learned Counsel for the respondent further submits that given the above, the grievances of the petitioner has been complied with by endorsing the case for preliminary case to the IO for preliminary inquiry. And there has been no any deliberate or willful disobedience of the court's order dated 12/7/2023, passed in WPC number 228/2023. And since the order has duly been complied with, this contempt petition, I praise for closing of this contempt petition. Since the order has substantially been complied with, the contempt petition may be closed. But both the Learned Counsel for the parties, and I have also produced the documents available on record. para. Where was the allegation by the petitioner?
There are 13, my lord, page
Chapter
8
13. Okay.
of the contempt petition, my lord. Page, oh, sorry, my lord, page 9,
9.
but it starts from page 8, my lord.
Okay.
There are 12 and 9.
It
12 and
appears,
15.
it appears that the petitioner was aggrieved by the inaction of the respondent contender, alleged contender, and therefore filed writ petition number 2228, WPC number 228, 2023,
23.
praying for direction to the respondent. Your prayer was for direction to the respondent to
Act in accordance with law, my lord.
act in the FIR lodged by the petitioner in accordance with law. After hearing the parties, learned counsel for the parties, as well as counsel for the parties, this court by an order dated 12/7/2023 has directed the responding alleged contender, the respondent number 4 of the writ in the said writ petition, that is the alleged contender. Respondent number 1 or 4?
No, in that writ petition, it was 4. my lord.
Writ petition number 4.
It was 4, my lord, but
Okay.
here it is
Okay.
sole contempt number.
4. To act upon the first information report, FIR dated 29/12/2024, lodged by the petitioner in accordance with law. On perusal of the record, it appears that on perusal of the records produced before this court, it appears that your complaint was lodged on
29/12/2022.
29/22.
12/22.
22, my lord.
And the action was taken on 13/1/2023, my lord. Before the order was passed, my lord. Already the
Okay.
SP, the content was already taken the action, my lord.
And
Page
your-
16, my lord.
where is the,
Page 16, my lord, of my affidavit, my lord.
yes.
Thirteen-one, my lord.
Okay.
Already it was forwarded to the competent authority, my lord. Since, my lord, there is an embargo under 17A, my lord, I cannot sumo to take action when the FIR is received, my lord.
To this, regarding this, where have you stated in your affidavit?
My lord, in my affidavit, my lord, page 11, my lord.
Okay.
No, para 11, my lord, page 8.
On 21st and so on, the commission can reduce the petition. So this 13/1/2023 is initiated by you.
Yes, my lord.
Okay. it appears that the respondent, Alice Contemptor, has initiated taking action on the FIR lodged by the.
May I please, my lord? 13, my lord, when it was received by the OC SIC, my lord, on 13th. So he writes to the SP, my lord, on 13th, my lord. Next page, my lord.
Okay.
On 16th,
It appears that on
Yes.
13/1/2023, the DSP, officer in charge
my lord,
of SIC, has written an office note to
the SP, my lord,
the
the contender, the present contender.
SP.
And SP sends
No,
this
he is SP.
on 16/1,
No, he is SP what?
SIC.
SPSI.
SIC.
Stroke the present contender, present Alice Contemptor. This is information.
No, he gives the information, my lord, and he gives a noting that it may be sent to the Secretary Vigilance, my lord.
Okay.
It is 16/1, my lord.
No. This 13 letter. 13 letter is written by the DSP to the SP.
Yes, and SP sends it to the for further on 16/1, my lord.
So, okay. And the Alice Contemptor on 16/1/2023. By this letter 16/1/2023, he is seeking
Permission from the,
permission for registration of.
yes,
the-
yes, my lord.
So,
No, no,
from whom? From whom?
from the Principal Secretary Vigilance, my lord.
Okay. By an office note dated 16/1/2023, sought for a permission for registration of the.
It is
Permission from
the Principal Secretary
the
Vigilance,
Principal
my lord.
Secretary
It is
Vigilance
already there in para 11, my
for
lord.
registration of the regular case. Para 11. Para
Yes.
11.
Paragraph 11, my lord. While file noting so and so dated 16/1 forwarded the same to the Principal Secretary Vigilance for approval from the competent
16/1.
authority, my lord.
Oh, wait, fine. No. No. Inquiry with 16. Okay. Yes, then change that one. No? In person to that, the Alice Contemptor, as per the mandate of section 17A of the PC Act 1988, when the complaint FIR dated 29/12/22 was received by him, he had by file noting dated 16/1/2023 forwarded the same to the Principal Secretary Vigilance for approval for the approval from the competent authority. So, thereafter, the approval under section 17A of the PC Act 1988 was received by the Alice Contemptor on 12/7/2023, and thereafter he had promptly on dated 13/7/2023 endorsed the matter to one Inspector W. Kamwa for conducting preliminary inquiry and to submit report. Start. Thus, it appears that the SIC, which PSENQ number 11/2/23 was registered in connection with the said FIR dated 29/12/2022. It also appears that during the inquiry, during the process of inquiry, the IO of the case has also recorded the statement of the informant under 161 CRPC and made some seizure from him, where the informant has
Submitted.
put his signature
Pen drive.
in the seizure memo. In light of the above fact and circumstances, it appears that and substantial order and the that comes on 12/7/2023 in WPC number. WPC number 228/2023. In view of the above, and since the direction has been substantial competition, approved is contempt. Okay. Accordingly, this contempt petition is disposed of. Okay. What was your submission? Your in
Well,
additional affidavit, what you have brought in some new?
Madam, we have brought in the fact that the IO had filed a status report pursuant to this order of this honorable court.
IO
my
has
lord.
not yet filed. Not yet filed.
No, we have filed a status report.
You have already filed.
Yes, we have already filed.
Have you seen the status report?
There is only no record, ma'am.
It's not on record.
It's in
It's
the
on
record.
record. It's on record, ma'am.
Where?
But there is a direction from this.
No, no, after status report, then the case must have registered or what?
No, my lord, the latest status report was filed. It is here on the records, my lord.
Where?
My lord, may kindly see, my lord, I think it was filed on. And in my additional affidavit, my lord. It was all on direction, on the direction of the zone report, my lord.
I have annexed in my additional affidavit also, man. Page
Where-
56.
Okay, where do we find
Of my
that?
additional
It starts
affidavit.
from page 56 of my.
And then one paragraph should over, should be added in the last, no? Direction to conduct preliminary inquiry and after seizure, after that sentence. And on completion of the preliminary inquiry, the IO has also submitted a status report on 27/1/2025. Wherein the IO has found prima facie case against
The accused person.
wherein the IO has just a minute, observed that prima facie case has been established against whom? Against the
DDSC, my lord. Inkyong.
allegation.
My lord, para 11, page 60, my lord. Page 60,
Hmm.
para 11. If
Page
your
60.
lordship. Para 11, my lord.
Para 11, page 60, my lord. Of my affidavit, ma'am. Additional affidavit, ma'am.
Just a minute.
Affidavit, additional affidavit filed by the petitioner. My lord, at para 11, it says, in the alleged conversation voice clip between complainant and DDSC Inkyong, Sri
Additional
Nakayam,
affidavit filed by the, no, not by the petitioner, additional affidavit filed by the respondent.
Yes, my lord, yes, my lord.
Where is your additional affidavit? Okay, affidavit. Your affidavit is available, filed by the petitioner, Contempt.
It was filed on 8th of March, my lord.
8th of March.
No, my lord, no, my lord. It is India affidavit, my lord. Affidavit
My
filed
lord,
by the,
status report. In
Yes.
my additional affidavit, I have annexed that status report, my lord,
my lord.
which was produced here, my lord. At page 60, my lord,
In my affidavit, my lord, it would be page 37, my lord. And the relevant portion would be, my lord,
Just a minute, let us look at it.
page 41.
Okay. Wherein the IO has observed that there is a prima facie what is that? The point of allegation has been made against the company,
in the company
made in the complaint
is established.
established, which needs proper and detailed investigation. So, investigation. Thereafter, this was filed on January. Whether the case thereafter registered?
No, my lord, it was filed on 8th, my lord. My lord,
27/1.
no. It was filed on, yes, my lord. 27th of Jan, my lord. Now,
Yes.
it has to be put up to the file, my lord. And my lord knows, my lord,
Okay.
it has to be submitted to the OC. OC will again give it to the
Okay.
SP.
Then
There's a procedure, my
after
lord.
that, the learned counsel, Mr.
And
Father, learned counsel for the respondent father submits that after filing of the status report, the matter has been placed before
The OCPS. my lord.
OCPS. SIC,
Yes, my lord.
SIC, and it will be,
It will be again, thereafter it will come to me, my lord. Since
okay,
it's a process, my lord. The file has to go, my lord.
okay. Before the OCPS. That's fine, and thereafter the rest will follow, okay? Okay.
Whatsoever, my lord, the order has been complied with, my lord. The only,
Yes, yes.
because here is
The last
since-
it is mentioned.
Yes, my lord.
Hmm.
It's a
Welcome.
contempt petition, my lord.
That way it has, the order has been complied.
My lord.
Okay.
I'm deeply aware.
Okay. Yes, this board. Yes. Yes.
Your Lordship, I'm appearing on behalf of Senior Counsel Mr. A. Apang for respondent number 125.
Hmm.
Your Lordship, as per on last occasion as well, the petitioners were absent.
No one appears on behalf of the petitioner on court. You are for the petitioner? Okay. Just wait there. You probably have to serve copies, requisite copies to the learned counsel for the exponent.
Your Lordship, we have received the extra copies. Yes, Your Lordship.
Okay. So you want to file what?
Your Lordship, as per my instructions, the petitioners can make their submissions regarding the question of maintainability that was raised by Mr. A. Apang,
No,
Senior.
not the petitioner regarding the maintainability. If you are raising,
Yes, sir, I am appearing for, I am appearing in item number 17, Your Honor. Is this item number 17? It is not showing in the display board.
17 for the petitioner.
17 for the petitioner. Yes, Your Honor.
Okay.
Your Honor, I am praying for allowing my application under Order 1, Rule 8. This writ application has been filed under Order 1, Rule 8 CPC. The copies have been served, Your Honor. It was a direction last date to serve copies on them, that copies have been served upon. And let them file their opposition.
You are filing objection. Are you filing objection?
Your Lordship, on regarding that, I have no instructions, but as per the instructions, they may make their submissions, and on the next date, we may be allowed to make our submissions.
Before making their submission, let them file their opposition, Your Honor, and Order 1 Rule 8 be allowed, because some people may join further in this writ application.
Okay. Who filed this IA?
Petitioner. I am appearing for the petitioner. I have filed the IA.
Okay. You file objection.
Okay, Your Lordship.
Okay. Mr.
I am Naresh Barodia, NARESH BALODIA.
N. Garodia.
N Balodia, yes,
I
BALODIA.
counsel for the petitioner. You are Miss
K. Loya, Your Lordship.
K. Loya. Counsel appearing on behalf of the respondent. Please for some time to file objection. Prayer allowed. Prayer allowed. Prayer allowed. This is matter after 2 weeks.
2 weeks.
Okay.
Much obliged, Your Honor.
Yes.
My lord, at number 19, my lord, I need some more time, my lord. 2 weeks time may be granted, my lord, to file affidavit opposition, my lord.
Okay.
And
Mr.
M. Nozimal.
Land counsel for the petitioner. Mr. T. Togum. Land Standing Council, Health and Family, Government of the State. Press for further 2 weeks time.
You might have filed one.
You have already filed.
No, at number 19, not filed.
19 filed, 20 not filed.
No.
This week, I need
Oh,
20.
yeah.
This is different.
Are you also filed?
In 20, we have filed.
Okay, you have filed. In 19, you are yet to file.
Yes.
Okay. Okay.
And
One more. Land council, for the state respondent. the Naric government advocate representing the state respondent and Mr. Peter. Naric Steering Council Head and Family Government MP prays for further 2 weeks time to file affidavit in opposition. Prayer allowed.
And my lord, item number 20, my lord, I'll not filing any separate affidavit. I'll be relying the affidavit filed by the respondent number 4.
Then list this matter after 2. This is with only then.
This is
Okay.
this item number
Okay,
19.
then in the and item number 19 then, huh?
Then
that
item
is
number
this after 2
20.
weeks. And after 19, in 19 his presence again. And then here you have already filed.
No, not yet filed.
Not yet filed.
20 they have filed.
No, that is why I'm saying.
Right.
19 over.
19
That will release after
After 2 weeks, my
2
lord.
weeks. Okay, so
20
20
we have
you have already filed.
And I'll be
So,
relying on the
If here
affidavit.
you are not, okay. Miss Wang Mo submits that he has already filed affidavit on behalf of the state respondent. Mr. Tita Gom, Land Standing Council, Health and Family Government Deputy. Submits that he is not filing affidavit in opposition in this.
Separate
Wait,
affidavit. I'll be not filing separate affidavit, but relying the affidavit of the
Okay, he is not filing, rather he will be relying on the affidavit filed by the state respondent.
my lord.
Let's pray for common, this is matter after 2 weeks.
My lord.
Okay,
My lord, interim order is there, my lord. Maybe can-
in both. In both.
Yes, my lord.
Okay, the interim order passed, habeas shall continue till the next returnable date, in both, huh? Okay.
20 on.
20
Okay.
only?
20. At number 20, there's interim.
No, interim.
20 only.
In 19 also, interim in 20 operated or just, there is no interim.
I believe there's no interim in 19 and 20
No,
there's
it
interim.
says, in 19 also, it says interim order passed in. Okay, both in the same order. Okay, in same order, huh? In the same order. The interim order passed in WPC number 170 AP 2024 shall continue till the next returnable date.
That is
All right.
May I please, Lord. Kindly, my lord, may kindly files to the office note dated 3rd of March. Unserved notice returned. Yes, ma'am. Unserved notice in respect of respondent number 4, ma'am. Respondent number.
Yes, I'm appearing for respondent number 4
You are for respondent number 4?
Yes.
You are appearing for the first time?
for the first time.
Okay, then it's fine.
And we have filed our
Wakalat
objection.
Nama is not there, ma'am. Wakalat Nama is not there, ma'am.
No, it was filed along with the affidavit at the time of filing.
You file Wakalat Nama,
Yes.
then. Okay. Or Mr. Islam, Lani counsel for the petitioner. And also Mr. Mahmood, Lani counsel appearing on, have you filed? Okay.
1, 2, 3.
Appearing on behalf of the state respondent number 1, 2, and 2. Mr.
M. Gamcham.
Would appear on behalf of the respondent number 4 and prays for some time to file Wakalat Nama.
No, we have already filed Wakalat Nama.
When?
We at the time of filing reply through
You have already
Katobai.
filed reply also?
Yes, we have filed reply and we have served the reply to the petition.
When? That's fine, my lord. So there is no any, my lord, the Wakalat Nama, my lord. So in record, my lord, this affidavit is also not there, but they have served me a copy. Oh, you have received the.
No, your lordship, in the record, it must be there. Because at the time I was filing the reply, it was, Wakalat Nama was filed along.
Mr. So and so, is there any affidavit? Respondent number 2 only. Yes, ma'am, only 2, ma'am. Your affidavit is not, has not yet come in record. It appears. I have checked the record, ma'am, that's why I'm submitting. And submits, would appear and submits that he has already filed affidavit in opposition on behalf of respondent number 4. However, the same is not on record. List this matter after 2 weeks along with the affidavit in opposition filed by the respondent number 4. Okay. There is interim order, that may be stop. In the meantime, the interim order passed earlier shall continue till the next examination date. Or by. Okay. Have you, you have received the copy? Yes, I have received the copy.
Your Lordship, I'm for the petitioner. I want to withdraw this writ petition.
You are for the petitioner?
Petitioner.
Yes. No. Mr.
M. Kamcham.
You are Mr.
M. Kamcham.
Counsel for the petitioner. So, Mr. He has an instruction to withdraw this writ petition. The prayer for withdrawal of this writ petition is allowed. Accordingly, this writ petition is dismissed on being withdrawn. Okay.
Obliged.
On withdrawn.
Yes, my lord. My lord, I am appearing for in item 24. I have filed the application, my lord, for vacating the stay. Because, my lord, there is an interim order in this case. And the interim order was based on a division bench writ appeal, which was pending before division bench. That has been decided now. So now, my lord, this entire matter is covered by the division bench judgment. So this becomes virtually infructuous, my lord. Lordship, may I kindly have my IA, which is numbered 35 of 2025. It will take hardly 10 minutes, my lord. I will just quickly.
You paid, no?
IA number 35, my lord. I have filed this IA,
35.
which is item number 24
Yes.
in the cause list. Item number 35,
Yes.
IA number, my lord. My lord, this is an IA which I have filed. Your lordship will see the order, interim order which was passed is at page 66, my lord, of this IA.
Yes.
Yes, my lord. So this is the interim order, my lord, on 25th of May, 2024. Now I will straightway come to the page 68, the relevant parameter.
Yes.
Para 8 and 8, 7 and 9, my lord. These are the three paragraphs. 8 and 9, sorry, 8 and 9. So in view of the submission made by the learned counsel for the petitioners and in support from learned deputy SGI, the court is inclined to direct Deputy Commissioner Divang Belli not to disperse any land acquisition compensation to the respondent number 7, which is me, my lord, respondent number 7. So Sri so and so in respect of any part of land in Malini village covered under so and so. 9, my lord. It is important. It is clarified that this order shall not come in any way of the implementation of any order which would be passed in connection with the writ appeal number 41 AP 2022. Now, my lord, this order has come, my lord. The other government has been imposed with the cost. This writ appeal has been dismissed, and they have been imposed with the cost of
appeal filed
against the same order, award, and the notification, my lord. This, my lord, arises out of land acquisition proceedings. So there was a notification in 2018 and subsequently there was an award. So that award was challenged by the government, the Assam Rifles, which was land was initially acquired by the Assam Rifles and later on it was handed over to the ITBP. So ITBP challenged that award, my lord. Till the division bench, there are 3 division bench orders. There are Supreme Court order also, my lord, and there is a contempt also. This I have just in a nutshell. List of things I have prepared. I will share with my learned friend also. Now, quickly, my lord, I will take your lordship to the facts of the case. Lordship may have this list of dates. So, my lord, 59 is the first date, my lord. This Assam Rifles took over this land. 2005, my lord, ITBP, it was handed over to the ITBP. 2017, my lord, on the right-hand side is the remark, my lord, first round of litigation. So respondent number 7 and others who were affected, the landowners, they have filed a writ petition before this court. And the court directed, serial number 4, my lord, that the DC should inquire whether this land is government land or community land and take appropriate action. Now that order I have at serial number 4. Number 5 and 6, my lord, subsequently, the government issues notification
and an award is passed, serial number 6th of September 2018. These two are in challenge before this writ petition, before your
So
lordship.
this, serial number 5.
5 and 6, the
5 and 6.
notification and the award. This
Then
is under challenge.
Acquisition and the award.
Sorry, ma'am.
Land acquisition.
Land acquisition is complete, my lord. Serial number 5 is serial number 6 is the award in the land acquisition.
6 is award.
Award, yes. So therefore,
Acquisition award. Okay.
this is under challenge, my lord. So this writ petition.
Who challenged this?
This now, my lord, the petitioners have been challenged it. They are 49 in numbers, my lord. They have filed this writ petition in January 2025. Now, before this award has been upheld by 3 division bench, and even it went up to Supreme Court. This award has been upheld, my lord. So now, after the final division bench order, which has been passed last year, my lord, in December, I think November, December, my lord, nothing survives in this case, because after serial number 7, 8, I will just quickly take your lordship what has happened. Serial number 8 is the second round of writ petition, my lord. After the award was passed, in serial number 6, there was no payment. These landowners, they filed a second number writ petition saying, please pay us. Next page, over the page. Serial number 9, this is the common order in those 2 writ petitions filed by the landowners. I was also a party, my lord. So their court directed to deposit the amount within 3 months. Then, my lord, serial number 10, they did not. Contempt was initiated, my lord. In serial number 11, my lord, the ITBP then files a writ appeal against that order of single judge that you deposit within 3 months. That writ appeal has been withdrawn, my lord. If your lordship see the description, ITBP files writ appeal against judgment dated so-and-so, which is later withdrawn with liberty to pursue other remedies. The said writ appeal came to be dismissed with withdrawn by the order dated so-and-so, granted liberty to the present appellants to pursue their remedy in accordance with the provisions stipulated in the Right to Act, Acquisition Act, my lord. Because it's an award, my lord, they cannot file a writ petition and writ appeal. Actually, they have to file an appeal under the 2013 Act. So that till that time was not filed, therefore it was withdrawn and the liberty was given. Serial number 12, my lord, the award, they challenged it under the Land Acquisition Act. That challenge appeal was also dismissed. Serial number 13, after dismissal, they again filed a writ petition, writ appeal against the single judge order, my lord, of 2019. Which again, my lord, serial number 14 is again dismissed, saying it cannot be done because you have other remedies, you go there. Serial number 14, my lord. Serial number 15, my lord, when the our contempt, which was filed in serial number 8, which came up before the single judge directed 45 days you pay. They gave an undertaking, you deposit the amount. So what they do, my lord, next over the page. What they do, my lord, instead of paying, they again initiate another set of writ petitions. This is the third round. On the right-hand side, I've mentioned below. This is the third round of writ petitions. Now, in that writ petition, single judge did not pass any order. And finally, court said that the contempt matter was taken up. Then what they did, my lord, against that order, they approached the Supreme Court, which is at serial number 18. Supreme Court also said, my lord, you deposit, then we will see. You should notice subject to deposit, my lord. Now, serial number 19, my lord, the Supreme Court dismissed the SLP also. Their SLP was also dismissed. But they, in the meantime, on serial number 21, they deposited the amount, my lord. And serial number 20 also, my lord, they initiated the writ appeals, which was initiated, my lord, that was also dismissed. So there are 3 rounds of writ petitions, my lord, and 3 rounds of writ appeals. So this is the third round. Finally, your lordship, see what they do when the payment is deposited, they again file a FIR. Serial number 23, FIR is also closed, saying these are all false allegations.
FIR against?
Against me, saying I have misrepresented. That is also closed.
Your respondent number?
7 here.
Okay.
I was throughout litigating. They never came before any. Now, serial number 24, my lord, this writ petition has been now filed, which is a 4th round of litigation. Now, if your lordship will see that there are 3 single judge orders upholding that award and the notification, and there are 3 division bench award. Now, your lordship will straight away come to the last division bench order, my lord. That is at page 164 in my IA. So it starts from 161, but 164 is the text of the judgment. One 164, my lord.
Of the IA.
Of the IA, my lord. This is the division the third division bench order. IA number.
You are Nasimena.
Nasimena, yes, my lord.
One 164.
Yes, my lord. This is the Lordship will say this is a division bench judgment of 21st of November 2024. This November last year. And this is the third division bench order, my lord. Now, para 4 onwards, para 4 to para 28, my lord, is whatever I have given your lordship in this list of date is the narration of all those cases. All those cases. Now, your lordship will see the finding of this. Kindly have page 175.
Yes.
It states, my lord, para 29, we have heard the learned counsel appearing for the parties. Now, lordship may come to the next page, 176, page 35. Here they have recorded, my lord, there were 2 objections in those petitions. It was recorded that the objection part is fourth line in para 35, that the objection pertains to the fixed rate of jurisdiction.
Which one?
Para 35, my lord.
Para 35.
35, my lord. This is the contention of the appellant in those cases, my lord. The objection of the present appellants were noticed and was recorded that the objections pertains to the rate fixed by the jurisdictional deputy commissioner for the purpose of computation of the value of the lands involved in the land acquisition award dated so and so. A further objection on the part of appellant herein that the award amount would not be called to be released on the ground that the ownership of the land is in dispute. It was not ascertained as to whether the land was community land or government land. So this was the issue before the division bench. Now, my lord, lordship will come to straight away page number, my lord, 178, 39, para 39.
Yes.
It is an admitted position that the appellants herein have not taken recourse of the proceedings under section 64 of the Right to Fair Compensation and Act 2013, presenting a challenge to the land acquisition award dated so and so. 41 again, my lord. The orders passed by this court dated so and so, writ appeal, dated so and so, writ appeal, not assailed and has attained finality to the directions passed by the learned single judge dated so and so in writ petition so and so, my lord. 42, my lord. The appellants herein have also not instituted any proceeding under section 64 right to fair compensation, although liberty was sought for them by them in the matter, withdrawing writ appeal and submitted in writ appeal to effect that the appellant herein are proposing to approach the competent forum to challenge the validity, legality of the award. Then they reproduce 37, my lord. 37 is important because this is the crux of the matter, my lord. It says that once an award is passed, it is final between the parties before the DM, even if they do not appear. So therefore, only a challenge can be under the Right to Fair Compensation Act. That says an award can be challenged under section 64. They have not challenged. They have filed as application appeal under 74 directly, which was dismissed. Now, my lord, para 44 is the repetition, para 45. The appellant herein, by way of their conduct, lordship has para 45, page 180. So the appellants herein, by way of their conduct, as demonstrated from the proceedings in the matter, both before the writ court as well as before the division bench of this court, has permitted the land acquisition award dated 6/9/2018 to have attained finality. The appellants herein, having not questioned the awarded amount in the manner provided in the Right to Fair Compensation 2013 and the learned single judge by order dated 7 November 2019 passed in writ petition so and so, having directed the appellants herein to deposit the awarded amount with the jurisdictional deputy commissioner, and such direction being passed after considering the objections raised in the matter by the appellants herein, and the rejection thereof, the appellants, by way of reiterating the very same objections, could not have instituted connected writ petitions, being writ petition number so and so, basing on the same grounds as was raised by it in earlier round of litigation involved in the proceedings so and so. The conduct of the appellants herein in the light of the various orders passed by this court in the connected proceedings would reveal that the appellants are only trying to institute proceeding one after another, seeking to delay the disbursement of the awarded amount involved in the land acquisition award dated 6/9/2018, and thereby causing prejudice to the private respondents herein. Then, my lord, lordship straight away come to 48, my lord, they discuss the principle of res judicata and estoppel. And then, my lord, your lordship will see 49. In the present proceedings, the writ court having noticed that the land acquisition award dated 6/9/2018 was not challenged by the appellants, had proceeded by judgment dated 7/11/2019, passed in so and so, to direct the appellants herein to deposit the awarded amount with the jurisdictional commissioner. And the appellants herein, in spite of having withdrawn the appeals so preferred in the matter in pursuance of the judgment dated 7/11/2019, on the plea of approaching the competent forum provided under the provisions of the Right to Fair Compensation Act 2013 to challenge the land acquisition award dated 6/9/2018. Admittedly, having not taken recourse to any such course of action, the judgment dated 7/11/2019 passed by the learned single judge, having been upheld by the division bench in the intra-court appeals so preferred by the appellants herein, it has to be held that by and between the parties involved has attained finality. Accordingly, the issue raised in the writ petition, being writ petition number so and so, having attained the issues so raised by the appellants herein in the proceedings dated so and so, the same would be hit by the principles of res judicata. Now, my lord, para 51. In view of the above discussion, we have the considered view that the order dated 8/9/2022 passed by the learned single judge in IA number, along with writ appeal number so and so and writ petition number so and so, is not erroneous and would not call for any interference. Noticing that the appellant herein had instituted connected writ petitions and writ appeals before this court without having taken recourse to the procedure as mandated under the provisions of the Right to Fair Compensation Act 2013 for challenging the land acquisition award dated 6/9/2018, it is being apparent that the appellant herein have, by instituting proceedings one after other before this court, only sought to delay the inevitable, that is, release of the awarded amount to the private respondent herein. We are of the further considered view that the conduct of the appellant's hearing cannot be condoned, and accordingly a cost of 25,000 is imposed upon the appellant herein in the matter. So, my lord, finally they impose costs on ITPP for repeatedly 3 rounds of writ petitions, my lord, and writ appeals, and including Supreme Court, my lord. We had to file contempt. Contempt order is also there, my lord. Now, my lord, after the dismissal of this, and when the matter was there, my lord, what they have done, this set of petitioners who are before your lordship now, what they have done, they have initially moved an IA for impleadment in those writ petitions, which was rejected, saying, you take your recourse, we will not implead you here, because the proper course is you have to challenge the award under the Act, Land Acquisition Act, which you have not done. So what they do, my lord, after that they come before in a fresh writ petition, and they concealed all this fact, because in the writ petition they say we are not aware of any litigation between the parties. We know something is pending, but we don't know what has happened. They do not disclose that so many division bench orders have come. Even the Supreme Court order is also there. Now they file this writ petition and they get this interim order, my lord, which I have read out. Now your lordship will come back to the interim order, page 66 again, my lord. I will just connect the entire what I have stated, my lord, in the list of date and the division bench judgment. Now, page 66. This is the interim order in this case, my lord. Lordship has that? Yes, my lord. Now, kindly have para 3. The case of the petitioner is that the entire acquisition proceedings were initiated behind the back of the petitioner, and they are not served with any notice about the intention of the respondents' authorities to acquire the land. Accordingly, having filed this writ petition under Article 226 of the Constitution of India, the petitioners have assailed the notification dated 24/4/2008, issued under Section 11 of the Right to Fair Compensation Act 2013. Gazette notification published on so and so in respect of the same, and the award dated 6/9/2018, as well as the notice of possession. So this is identically which has been upheld by the division bench in all those judgments. This award, this notification has been upheld. The entire procedure, the same grounds were taken by the government in ITBP in those proceedings. They tried to intervene, they fail. Now they file this in a separate. Now what they're asking your lordship to do, my lord, virtually your lordship, they are asking your lordship to set aside a division bench judgment, in fact, 3 division bench judgments, and a Supreme Court order by which they have been directed to deposit, my lord. Now, para number 4, my lord, page 67, which is also relevant, my lord. In support of the contention of the petitioner, Mr. M. Kato, learned Deputy SGI, submitted that the stand of the Union of India is that the proper procedure for the land acquisition was not followed by the authority in this case. He also submits that initially the land was provided in the Assam Rifles in the year so-and-so, and that the ITBP now in possession of the said land through Assam Rifles. It is submitted that the stand of the Union of India is that the proper procedure was not followed in the entire acquisition process. He also submits that the Union of India is also put up a challenge in the acquisition proceedings, which is now part of writ appeal number so-and-so. This is the writ appeal, my lord, which I have shown. The judgment is reserved by the division bench. That time it was reserved by the division bench. Issue notice returnable, the petitioner shall take steps. Para 8 is relevant. In view of the submissions made by the learned counsel of the petitioners and in support of the learned SGI, the court is inclined to direct the Deputy Commissioner, Land Acquisition Authority, Dibang Valley, not to disburse any land compensation to the respondent number 7 in respect of any land in Malini village to the amount of so-and-so. It is clarified. Now, 9 is very nice. Clarified the order shall not come in any way implementing the order that would be passed in connection with the writ appeal number 41, my lord. My lord, before, when this order was taken, my lord, that was not disclosed. There are so many judgments, my lord, because the writ petition does not disclose. There are 3 more, total 3, that time 2 division bench judgments. And now, my lord, after this order, the latest November 2024, the 3rd division bench judgment has also come, which I have just read out to your lordship. So it is saying continuously, my lord, they are delaying, my lord. Now, the principle, my lord, is this, that there has to be finality of judicial proceedings, my lord. That is the principle of law, my lord. Because, my lord, if your lordship decides something today, my lord, now it can be set aside only by a division bench, my lord, not by a coordinate bench, my lord. They cannot, a litigant or any other litigant cannot repeatedly come before a single judge and say ki the other coordinate bench passed an order, that is wrong. The steps are, my lord, that it has to be by a division bench, which is well known, my lord, which is that is the principle of judicial precedence, my lord.
This is vacation petition.
Yes, my lord. We have filed this vacation petition, my lord. We have.
You have filed any objection?
Yes, I have filed.
You filed?
Yes.
Okay.
They filed. The pleadings are complete. It's ready for. It was last time. Today it was fixed for hearing, my lord. Because last time they took time, so it was fixed for hearing, my lord. So, my lord, I will just wrap up, my lord, that under the principle of judicial precedence, my lord, one subset is, my lord, that it is res judicata, my lord, and another subset is, my lord, that stay decisis, that principle of, you know, single judge is bound by a division judge, my lord. That is the doctrine of stay decisis, my lord. Now, res judicata, my lord, normally is between the same parties, constructive res judicata or res judicata, which, my lord, is bound, government is bound by those decisions, division bench. Even any other third party, my lord, like them, because basically they are now the front, my lord, of the government. Government has failed. Now they have put up local people and they are trying to disturb this. So therefore, my lord, even in that case, my lord, the only remedy they have, because the principle of stay decisis has to be followed. Your lordship will not disturb a division bench, in fact, 3 division bench and 1 Supreme Court judgment, my lord, on the basis of their writ petition, my lord. The remedy available to them is that they should file an SLP against the division bench order. Till date, they have not filed, my lord. The limitation period is over. November was the order. Till date, there is no record in the Supreme Court that they have filed. So instead of filing an SLP, which is the right remedy, they have not filed. And now they are litigating again and again. They're filing writ petition and getting concealing orders, my lord. In fact, this is a perjury, my lord, to not stating the correct facts. There's so many orders, my lord. The list of data I have given, my lord. That's my short submission, my lord. Great.
Mayor.
Yes.
My lord, may please come to IA 35 filed by the applicant, my lord, at page 69.
By the way, where is your affidavit?
My affidavit, my lord, is there.
Objection.
Yes. I have
Okay, it's here. Okay. It's there.
Mayor. Yes. Well, I would like to introduce the applicant here, the private respondent 7. Who is he, my lord? My lord, may please come to page 69 now. Of the IA filed by the applicant, my lord. Page 69, my lord.
Just a minute. Page
69.
69.
Yeah.
Of the
IA.
IA.
IA
Okay.
filed by the applicant.
It's a government gazette notification.
Yes, ma'am, yes. Gazette notification. This is only a gazette notification.
Hmm.
Now, my lord, this is for acquisition of Malini. My lord, may I please come to page 70, my lord, the area, my lord, the scheduled area, schedule number 5, my lord. Malini. On the top, my lord. Page 70, my lord. The notification, part of the notification.
Page 70.
Yes, ma'am, 70. On the top, my lord, Malini.
Malini.
Yes, ma'am. This Malini, my lord,
Yes.
is located at Malini village, my lord. This area.
Yes.
Now, my lord, and my lord, this is, now, my lord, may please come to page 103, my lord. I will demonstrate, my lord, he is a fraudster, my lord. Yes.
The area.
Yes, my lord. This Malini, my lord, the area, the land which is required to be acquired, my lord, is located at Malini, my lord. And I say he is not from Malini, my lord. So why, my lord? Page 103, my lord. Please,
Lordship will just permit me. Lord, these are on merit, my lord. If your lordship goes into this and if he is allowed to show, my lord, that will be setting aside a division bench. First, my lord,
No, I will clarify everything.
Because these are on merit, which
I
has
will
been upheld.
clarify everything, my lord. Page 103, my lord. This is the writ petition filed by the applicant, my lord. Page 103, annexure 8, my lord. I will show how is it fraudster, my lord. Page 103, my lord. Yes, WPC 78 of 2017, my lord. They have filed, my lord, Nasi Mena. Applicant hearing. Now, my lord, may please come to page 104, my lord. 104, my lord. 104, my lord.
Yes.
Yes, my lord. See the address, my lord. Sri Nasi Mena, son of so and so, permanent resident of Malini village, my lord. He says he is from Malini village. Yes, my lord. Now, my lord, may please come to page 107, my lord, of the judgment. This is the judgment, my lord. Fourth paragraph, my lord.
This is the first judgment.
Yes, my lord. Fourth paragraph, page 107. It is the case of the petitioner that the writ petitioner is a permanent resident of Malini village under Italian circle under Dibangali district, and their community land was taken by the ITP from Assam Rifles in the year 2005. So he, my lord, addresses himself as a permanent resident of Malini, and land sought to be acquired is located at Malini, my lord. Now he says this is a community land, my lord. Now, my lord, may please come to page 128, my lord. In the series of litigation, my lord, they have committed fraud upon this court also. Page, my lord, 127, my lord, writ appeal, my lord. Page 127, my lord. 127.
Yes.
Yes. This is the writ appeal 195 of 2022, annexure 11. Now, my lord, page 128, my lord. Versus, my lord, after 5, the commandant versus Sri Ngasi Mena and 4 others, son of so permanent resident of Malini, Italian circle. He has been introducing himself as a resident of Malini village, my lord. Now, my lord, may please come to page 138. I will slowly demonstrate, my lord, who is he. Page 137, my lord. This is also writ petition number 190 of 2022, my lord. Page 137, my lord. Yes, my lord. My lord, may please come to page 138, my lord. Here, respondent number 8, also, my lord. Nasi Mena, permanent resident of Malini, my lord. In the entire, my lord, litigation, my lord, in the proceedings before this honorable court, he has introduced himself as a, my lord, as a resident of Malini, my lord. Now, my lord, may please come to page 154, my lord.
in the contempt proceeding, my lord. Page 154, my lord. Annex 14, my lord. One, my lord. Petition number one. Nasi Mena, son of Soja, permanent resident of Malini, my lord. Now, my lord, again in one page 161, my lord, read appeal, my lord. 161. Number 4, my lord, respondent number 4, my lord. Nasi Mena, son of Soja, permanent resident of Malini, my lord. So he has been introducing himself as a, my lord, a resident of Malini, my lord. Now, my lord, may I please come to page 115. 115. This is the award, my lord. My lord, 114, sorry, my lord, 114. 114 is the award, my lord. Now, my lord, this is the award. Now, page 115, my lord. The award, my lord, is for, my lord, Malini, my lord. May I please come to third column, my lord. Area Malini, my lord. Award has also been passed in respect of Malini, my lord. It comes under Malini village, my lord. And again, my lord, page 116, my lord. Here the location is there. Serial number, my lord, 1, my lord. Name of the landowner, Nasi Mena, village Malini, my lord. Yes, yes. Now, my lord, he suddenly changes his, my lord, address, my lord, after filing of this writ petition by the villagers of Malini, my lord. Now, my lord, please come to page, my lord, page 16 of this IM. Page 16, my lord. He changes his address now. Page 16, my lord. Nasi Mena, my lord, on the top, my lord. Page 16. Nasi Mena, permanent resident of village Ichenali. Now he changes himself, my lord, and introduces himself as a resident of Ichenali. Even, my lord, in para 52, my lord. In my affidavit in opposition, my lord. My lord, we can continue after this already 1, 2. Yes. Okay. Well, I will mention one item. Which item? Item 27, and this item 6 of code number 1 at a similar matter. The code number 1 item 27 of this thing. Okay. And item 6 of code number 1 is the same matter. So code number 1 is directed to take up the matter together. Together. Yes, it was in motion. Okay. So I think the file is not reached. So let it be tomorrow. This one? Yes, this along with item number 6 of code number 1. Okay. Tomorrow, list already prepared. Day after tomorrow? Yes. Go to tomorrow list. Thank you. That's good. Okay, it's praise for God. You are for the petition? Yes, I'm for the petition. Okay. Along with this. Okay. Petition number 100. The petition, so and so. List this matter. Along with petition number 100. Along with 11. Number 100. 100. 111 of 2020. 111 of 2020. 25. On 20. Okay. What is this matter about? It's related to tender. Okay. Already this court number 1 is passed order to be taken up together. Okay.
Your Lordship, I beg to mention item number 12 and 13, Your Lordship, and for the petitioner, I was listed as absent, Your Lordship, and there, Your Lordship.
Absent only?
Yes, Your Lordship. Actually, I was present, Your Lordship, due to some urgency, I went outside, so. Your Lordship, within 2 days, I may be allowed to take steps.
What are already passed?
Your Lordship, my name. Kindly, my name may be reflected in the of the Your Lordship. For the petitioner.
Who has recorded? Yeju. Matsukato also appeared. Right. Okay. Then attendance may be recorded then
Yes, Your Lordship.
in 12 and 13.
Yes, Your Lordship, 12 and 13. And Your Lordship, within 2 days.
Try to appear and be present.
Yes, Lordship.
And then every time all the item you mention later on, it will be very difficult because PS, one PS recorded and another PS is very difficult.
Yeah.
Don't repeat it.
Yes, Your Lordship. Sorry, Your Lordship. Deeply obliged.
Grateful.
List is matter again on Monday. Okay. The other one, earlier one, Monday along with the petition of 95. Okay. So 95 also on Monday next week. Huh? Okay. Yes. Well, no, well, just a minute, just a minute. Yeah. If this was further, having gone through. The office note, it was written, affidavit not yet filed by the state respondent. State respondent has filed affidavit.
No, madam. This matter.
Yes.
Okay.
State is filing,
No.
not filing.
We will be filing.
My lord, the state, they have been imposed cost, my lord, on this, because that writ petition, writ appeal order, they have been imposed with cost of 25,000, my lord. So-
Okay.
So they doesn't, their grounds, my lord, have already been rejected by the division bench and with the cost. So
No,
there's,
just because in this office note, are you filing?
We will be required to file in this present writ petition. We will required to file
Affidavit.
my lord,
In IA?
they have not implemented us as a party also.
But in
IA
IA, okay, this is in the writ petition.
IA in the writ
in the
petition-
25, item number 25, my lord, that is the writ petition.
Okay.
There they may file, my lord, the
In
reply.
fact, in the IA also, we should also have been at least made a party.
My lord,
Why you have not made party?
my IA, they are party, my lord.
They are party?
Yes, yes, because the cost title is the same, my lord.
No.
We have not been. Copy also, today I have asked from them.
If your lordship see page 15 of my IA.
State is also party.
Yes, yes,
In
everybody.
IA law.
This is the
They have not made state as a party.
state as a party in the IA. This is the post title of writ petition, the writ petition. And the main post title of this I starts from page 16. Yes. Applicant. And all the private respondents. The state is not a party.
Yes, whether the state is not an asset. State is not an
because,
asset party here.
because the division bench, my lord, their case has been rejected by the division bench, my lord.
No.
So this stay,
You are
this is,
filing this
ha,
application under
this is as
for vacation.
151, you know.
Vacation, but the state order was passed in writ petition where the state is also party.
State is party, my lord, but the order has been passed at his instance. He is the writ petitioner, my lord. And the direction is that the DEC will not release the payment. That is the only direction, my lord. The state's contention in this has been adjudicated repeatedly 3 times. Latest November 2000 by division bench, my lord. So they are basically, they are not performer parties only because they have to file an SLP if they have to. Because here they have no role. Because it is only their contention now saying that they are also owner. After 12 years they have come, not before the, and in a writ petition. not even in the land acquisition proceedings, my lord. So state has virtually no role, my lord. They are performer parties. Therefore, my lord, and that paragraph I have read out, my lord, division bench paragraph, where all the contention of the states, lordship may kindly have.
What is the prayer in the writ petition?
Prayer is the writ petition is, my lord, set aside the award. The same
And
which
that
has been
was-
upheld by the division bench.
And
Kindly
that-
have the prayer, my lord. Kindly have the prayer, my lord. The writ petition, your lordship will have page number
51.
in the writ petition, my lord, page number 33.
No,
start.
this is for.
33, my lord, writ petition. That is serial number 25. Okay, 34, it starts at 33. 34 is the main prayer number 1. A writ of certiorari, quashing, setting aside impugn notification. This is a notification which has been upheld by the division bench. 2, certiorari quashing the notification that at 10.5. This is also upheld.
MP notification 24 2018 has been
Upheld by the division bench, yes.
division bench.
3 division bench, my lord. The latest I have shown. Number 2 also upheld by division. Number 3 also is the award which has been upheld by the division bench. And they have imposed cost on the state. And only remedy, both of them has only SLP, my lord. Not before again initiating a writ petition.
But I will clarify everything.
That is why I said, my lord, very initially, my lord, that principles of finality of judicial proceedings, my lord, that this is stay assessed, my lord. Lordship, even if for lordship, he demonstrates before lordship, I'm a fraudster. My analysis started from that. But I will demonstrate I'm not, because I have very valid grounds. But even if he able to demonstrate, your lordship will not be, setting aside a division which has been upheld by the division bench. So they should be better advised to file an SLP against that order, impleting all these grounds, whatever grounds they have under law. So all this, my lord, has been upheld, because if your lordship see prayer number 4, impugn notice, this is 2019. This is the notice by which they have been asked to come and collect, which they did not turn up. My lord, the interesting part is, my lord, they came in the picture only in after January 2013, after the Supreme Court order in the SLP. When the amount was deposited, my lord, for the first time, they filed an FIR against me. That FIR has been closed by a detailed order, my lord. Kindly have that order. A detailed order.
Just a minute.
Huh.
My lord, the issue before the earlier litigation and now is different, completely different. I will demonstrate. This impugn notification dated 24/4/2018.
Yes.
Has been set aside and passed by upheld by the
Division bench. Division bench.
In
November.
which case? In which case?
This I kindly have this. Kindly have page number. Page number, my lord. 161. This is the case, my lord.
161 of not upheld, my lord. It was not challenged, my lord.
No, it was challenged. I will show, my lord. They have upheld. Kindly see. Page 161 is the division bench order. Lordship has seen 2 judges of
161 of
the IA. They have not annexed this problem. That's the problem. In the writ petition, they have not annexed anything. And they got an interim order. 164.
I may be
164.
Let me just clarify. Yes, sir. Let me know the
Huh.
I will clarify everything, my lord. What is others?
164 lordship has.
The 24/4/2018 is a notification that is issued by the secretary. Then where do we find in?
Yes, my lord. So therefore, my lord, lordship will see. Lordship may straight away come to. This is the starting. I've shown the division bench 2 judges, my lord, November 2024, and then your lordship will see that the.
Just a minute. 2018.
Para 5, Your Lordship.
Share of five.
Para 5, yes. Para 6, my lord, it's clear. On conclusion of the 66 page. On conclusion of the proceedings, mandated under Right to Fair Compensation Act 2013, para 6 I'm reading. In pursuance of the issuance of notification, that is 24/4/2018. This is the specific under section 11 of the act. The deputy collector proceeded and issued a land acquisition award dated so and so by notification at 6/9/2000. This is the same prayer. And this has been upheld by the division bench, which I have shown, my lord. Kindly have the page 178, which para 39. Page 178.
Page 1,
7/8.
7, 8. Oh,
Of this judgment only. I'm showing the conclusion now. The DB judgment. Page
170.
39. So 178, my lord, para 39.
Yes.
So it is an admitted position that the appellants herein have not taken recourse of the proceedings under section 64 of the Right to Fair Compensation Act, presenting a challenge to the land acquisition award of 2/6/2018, para 41, my lord. The order passed by this court dated 7/10/2011, read appeal number so-and-so, and order dated read appeal not being assailed has attained finality with the direction so-and-so. These are the all previous read appeals, my lord. Where?
So we were concerned with April 24, 2018.
24.
No, order dated April 20, what's your?
My lord.
24, 24 April 2018.
Correct. So these are all the same.
Wait, 41 is about?
So they are also in read appeal. Those read appeals also, my lord, same notification and award was challenged.
No, don't confuse it. I want to clarify one by one. This 24/4/2018 is upheld by para
upheld by, just show me.
6.
So para 6 is the narration. This is challenged.
Yes.
Kindly see finally para 51, page 183. Para 49, in fact, page 182. Lordship has 49?
49.
Yes.
Whether 49 talk about this
49, page.
notification 24/4.
24/4 is the notification, my lord. Final award is 6/9/2018. First is the notification, then followed by the award. 49 records, the award has been upheld. That means the notification also has been upheld. Page para 49.
Yes.
Kindly see the present proceedings. The read court, having noticed that the land acquisition award dated 6/9/18 was not challenged by the appellants and had proceeded by judgment dated so and so to direct the appellants herein to deposit the awarded amount in the jurisdictional deputy commissioner. In spite of having withdrawn the appeal so preferred in the matter pursuant to the judgment dated 7/11/2019 on the plea of approaching the competent forum provided under the Right to Fair Compensation Act to challenge the land acquisition award dated 6/9, admittedly having not taken recourse to any such course action, the judgment dated 7/11/2019 passed by the single judge having been upheld by the division bench in the intra-court appeal so preferred by the appellants herein, if having appellants against it has to be held to have between the parties involved attained finality. Now kindly see para 50 also, para 51. So they upheld, my lord, the entire procedure, the entire land acquisition procedure has been upheld. So your lordship have this, my list of date also, which I have handed over, my lord. That there I have very, conveniently, my lord, because that is a very good reference point, my lord.
And what is this 10/5/2018?
10/5/2018 is again a notice, my lord. This is basically they were called to appear before the award, where the DM was conducting award, because that's the process of award. Before award, they have to issue notice to the parties. Everywhere he has to come. So that was another notice. Even after the award, my lord, in January 2019, there is another notification, which was also upheld because that is a notification of 30 days. He come and collect the money.
And 6/9/2018.
6/9 is the award, my lord. Award. So entire procedure has been upheld
So 6/9/2018 was upheld by
the division bench, my lord.
division bench by the same order.
Same order. Para 49 I have shown, my lord. Para 52 also. Kindly have para 52, my lord. Lordship has para 52. Para 52 at page, my lord, 183. Where again they say, my lord, noting that the appellants herein had instituted connected writ petitions and writ appeals before this court without having taken recourse to the procedures as mandated under 2013 Act for challenging the land acquisition award dated 6/9/2018, it is being apparent that the appellants herein have, by instituting proceedings one after other before the court, only sought to delay the inevitable release of the awarded amount. We are of the further considered view that the conduct of the appellants herein cannot be condoned. Accordingly, a cost of 25,000 is imposed upon the appellants herein in the matter.
So here in that case,
Huh.
appellant is
the Union of India. Union of India.
Not the state.
not the state.
State has throughout supported, my lord, the land acquisition. So, my lord, repeatedly, my lord, lordship may have the list of date I have given in the
Yes, because
lordship has that.
no,
So I'll just quickly, my lord, it will be very convenient, my lord.
just a minute, just a
Huh.
minute. And what about this 22/1/19
To 22.
prayer 4?
22/1/19 is the notice, my lord, by which, my lord, this has been, they were asked to come and collect the money. That is the 30 days notice, my lord. My lord, that also is after the award, my lord. When the award is upheld, my lord, that is automatically upheld. There is no need for a separate challenge or separate finding because the award has been upheld. So consequently, the steps that is to be taken under the award is always, my lord. I'm sure, my lord, it is also finds mentioned somewhere. So, my lord, lordship may kindly have that list of dates. Lordship has that. I'm sorry. I'm sorry.
So when the petitioner obtained this interim, so these whole notification and the orders upholding,
Yes.
these were not brought into the
No,
notice
no,
of the
no,
court.
my lord. In fact, the writ petition, they say ki they were not aware, though, which is not correct.
Okay.
Because the IA also earlier in 2022, they filed, which they withdraw, because the court said ki nothing doing, you cannot be implemented in these proceedings. So they withdraw. But those things.
So those orders were not annexed.
Yes, not annexed, not at all. None of them. 3 single judge, 3 division bench, Supreme Court, none of them. What happened, my lord, after the dismissal of the SLP in January, when it was directed that they should deposit, in January 2023, they deposited the amount before the district administration, the ITBP. Now, after that, my lord, the entire activity started. What they are doing is, my lord, they filed an FIR. That FIR, my lord, final report has been filed, it has been closed. Because the
FIR file against whom?
Against me, saying ki I have forged. Kindly have that report, my lord. Kindly have that enquiry report, my lord. Page number. Yes, my lord.
So this connection with the writ appeal number 41.
And 42.
What is this 41?
So 41, what happened, my lord? Your lordship, that's why I'm saying, my lord, the list of dates, my lord. That will be, it will clear everything, the list of dates.
Yeah. Yes.
Kindly have 3, serial number 3, first page.
Yes.
So I have given the date
2017.
17, and on the right hand side, lordship will see remarks, first round of litigation. Lordship will see, we have filed first round saying ki, please do something, this is our land. ITBP cannot take it away without payment of compensation.
Respondent number 7. Another.
So this is the first round.
Okay, what direction?
So serial number 4.
What was the direction?
Serial number 4, lordship will see the Honorable High Court by order dated.
No, serial number 4 or 3?
Yes.
No, serial number 4 or 3?
3 is the filing of the
litigation. Serial number 3.
3 is the filing of the writ petition. 4 is the order, my lord, in the final order.
Okay.
14/3/2017. So it said that directed the district commissioner to investigate and find out the status of the land. So after that investigation, my lord, April 2018, that notification which has been upheld, 24th of April 2018, that was passed. That is serial number 5.
So based on the court direction.
Correct. Government took a decision. This is private land. We have to acquire this land for ITBP. Notification issued and then award was passed, my lord, 6th of September 2018. 5 and 6 are challenged in this petition also.
Just a minute.
Yes, my lord.
This 4 is the.
4 is the direction of the single judge.
4th April is the direction of the single judge.
4th April is the notification, my lord. 14th of March, just before that, is the direction.
14 is the direction and 4th is
notification.
So 4th is the notification.
Yes.
And this was upheld.
This was notification as well as serial number 6, my lord. 6 September 2018 is the award. And these two are challenged throughout, my lord.
These two were challenged.
So these are the what your lordship find in the division bench. This has been upheld. Not only once, I will just show from in this document only 3 times. So lordship mentioned serial number 7. Lordship mentioned one date, 22nd of January 2019, which is in their prayer. This is a land acquisition certificate notification issued to the so and so money village will be taken. So it is after award. There is a process, your lordship, that they will issue notice. DM will issue notice to come and collect money. That is the word. So
Yes,
once
sir.
the award is upheld,
22/19. Notification issued. 22 January 19.
yes, my lord. That is a regulation, my lord. A regulation notice is issued to everybody. Whoever name has come in the award, you come and collect. This is your portion. You can come and collect. So that is a formality, my lord. After the award, once the award is upheld, this doesn't make any difference, my lord. Now 8 is, my lord, second round because they were not paying money. So we have to again go to the court. We filed a writ petition again, saying that they are not releasing the money. They have passed an award, but not releasing the money. Now, serial number 9 is the order in that.
No. First round was challenging what?
First round was, sir, that the court, the IDPP is taking the land without paying us anything. This is our land.
Okay.
So court directed the DM to find out what is the status of the land, whether it is government or private, and take appropriate action. So therefore, government investigated and found private land, notification issued, award passed. These are
Where is the government notification? This.
This is what has been challenged, my lord. Lordship will see this is at page number. I have mentioned the page number also on the right hand side, my lord. If your lordship see serial number 5, page number 69 of the IA paper book. So it is there, my lord.
So this is.
So
page 69 is the.
Of the IA.
69 of the IA is the acquisition notification.
Yes.
Just let us just see.
Yes.
I haven't seen. That is why.
No, please. Lordship will satisfy your lordship and then only. We are here to assist only.
So this is the notification.
Notification. Lordship will see there is a page 70. Malini, page 70, first village is Malini. This is the main. So lordship will see on the right hand side, Meena clan community land. So this is what was there. So now this notification is followed by the award.
Just a minute. This notification says what it says.
It says that these are the land.
They have a right to.
These are the land required for ITPP for outpost, and we are acquiring this land. Anybody wants to come and oppose, may come and oppose.
Okay. So,
and this resulted into the award, my lord. That is serial number 6. The page number I have mentioned, my lord, serial number 6 of my LOD, last part. Page number 111 of the IA paperwork. Triple one of the IA paperwork. 111 is actually a covering letter of the award. Award starts at 112.
Okay.
Yes.
This is 111
Is a covering letter, my lord. This award is forwarded to the ITPP for their information and payment. So 112.
That copy is 112.
Yes. So lordship will see the date 6th of September 2018.
7th.
6th September 2018.
Which one?
On page number 112, date of the award.
Date of the award. 6th or 7th?
6th.
Page 112.
Yes.
It's
lordship,
7th September. 7th or 6th?
It is 6th, my lord. It is 6th. That may be a printing mistake. It's 6th. Everywhere it is 6th. Even the.
You have typed. You just see it once.
115, it is 7. Typing.
Well, lordship has 112 page number.
112, yes.
Of the IA.
Yes. September 2015.
No, my lord, it is a typo mistake, my lord. That's not disputed by anybody, my lord. The award was passed on 6th of September.
Okay.
So here your lordship will see, they have mentioned the area and all, the compensation amount, and page number 114. Yes.
When required for helipad.
Hmm.
MIP.
The 4 villages involved. Lordship will find that 4 village at page number 114. That there is a table. That is the apportionment. Lordship has 114.
This 6th September is
Yes.
regarding land acquisition. What did you say? This notification, this letter
Lordship
is 6th April. Sorry, 6th September is
the award. Page 112.
112 is the award. Deputy Commissioner address to the commandant.
No, sir. The Lordship will see page 111. 111 is the deputy commandant. That is the letter.
No, probably.
Achha, it is 1111. I'm sorry. That's correct. 112. That is the letter. It's a covering letter to the commandant annexing the award.
Okay.
Next page is the award.
114.
Yes. Physical file. आपके पास आएगी तो physical file देखिए अच्छा सर के पास So Lordship will see 114.
Is then acquisition award.
Yes. Lordship is having the IA paper book?
Yes.
IA paper book. Okay.
This is award.
Yes, my lord.
So,
and this too has been upheld by the division bench. Now they cannot again come before this court, my lord, and ask, because this will be unsettling the division bench order.
so this award is to be paid to whom?
To my lord, the 4 people may kindly have page there is a table, my lord, just after the award.
Okay.
Lordship has a schedule 2. Schedule 2, there are names.
Schedule 1, schedule 2.
Schedule 2, yeah. There are names, my lord, and there are villages. So 1 to 4, my lord, 2, 3, 4 has been paid after the Supreme Court order.
2, 3,
4.
4 paid.
Paid Supreme Court at the last division bench order. What they did, my lord, they concealed all this litigation and got this order.
This is as part of paid as per the order of.
This is paid as per the order of the division bench, which I have shown, my lord, 24th of November 2024. 21st of November.
21st.
21st of November.
2024. So this is annexure?
This is annexure 16. 16. Page number 161 of the IA.
Only Nasi Mena was not paid.
Because they got an interim order against him, concealing all those facts. And this all throughout is an uphill, my lord. Now they are trying to agitate this, my lord, because whatever they have to agitate, my lord, they have to do it before after the division bench. It is only Supreme Court.
So they were paid as per the order of 21/11/2024.
Yes, that's after the order was passed, division bench again upheld the award and the notification. Then the payment was released.
When it was released?
This must be, my lord, after that, November, maybe December, January, like that.
Okay, so when 161.
161 kindly have.
Okay. Operative portion is?
Operating portion is, my lord, page number. I will just show, my lord. Page number, lordship will come 175. Para 29, it starts, my lord. That findings. Lordship will have para 35. (176) para 35. So these are the two grounds on which it was challenged, my lord. The rate is higher, fourth line from the top. And then
Para
35, my lord.
35 or 25?
35. I'm sorry, 35. Page number 176. I'm so sorry. So these are the grounds that was taken, you know, that rate was not.
So initially it was okay, allowed by the single judge.
So that is
7/11/2019.
19. That is my list of date, my lord.
So who filed appeal?
That was we filed, my lord. Serial number in my list of dates, serial number 8, 9, my lord.
No, where?
In the list of LOD,
No,
my list of
who
dates.
filed this? Writ petition, who filed?
The first two writ petitions, my lord, the landowners, we filed. We filed. So in this writ petition, one writ petition was before the award. Ultimately, award was passed. Second writ petition was filed by us since they were not releasing the payment. So division bench holds that also has become final.
So by this judgment and order dated 7/11/2019, what was the direction?
Direction that they should deposit the amount, entire amount with the DM within 30 days. So 3 months.
Whether in this direction, your amount, your awarded amount also covered?
Yes, or entire amount.
Entire amount.
Yes, entire amount.
So accordingly, they have deposited.
So they did not deposit immediately. There are several other rounds. Finally, after the Supreme Court order, in January 2023, they deposited.
2023, they deposited.
So that your lordship will be in the list of date. It is there, my lord. Kindly have the list of date. So what they have done, my lord, after this single judge order of 2019, they filed again writ petition against that. They withdraw those writ petitions. I'm sorry, writ appeals before the division bench. They withdraw those writ appeals. And then they file an appeal under section 74 of the Land Acquisition Act. That is also dismissed. Para 41. 41 and 42. The record, the writ appeal also dismissed. 42, the record, the LA appeal is also dismissed. 43, Lordship has that para 43. Well, para 43, Your Lordship, I want to show one thing. That is, section 37 has been reproduced in para 43. So, Lordship has that para 43, you know? So it says, my lord, it is the finality of the award, my lord, section 37 of the act. It says, I will read out, my lord, subsection 1, the award shall be final in the collector's office and shall accept as hereinafter provided. Accept as hereinafter provided means in the act of 2013 shall be final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, of the not of the true area and market value of the and the assets attached thereto, solitium and determined, and the apportionment of compensation among the parties. So, my lord, whether this petitioner has appeared before, not appeared before, only way to challenge is except otherwise provided the act, which is the appeal under the act. They cannot file writ petitions. So that is what, my lord, para 44, the division bench has interpreted. I will read out. Perusal of the provisions of section 37(1) of the Right to Compensation Act reveals that the award passed by the collector under section 23 of the act would be final and conclusive evidence that between the collector and the person interested. They are also claiming to be interested. It further provides that whether or not the person interested have respectfully appeared before the collector or not, the award shall be conclusive of the true area market value and the assets attached thereto, solitium determined, and the apportionment of the compensation among the person concerned. So this apportionment they are disputing. They are now saying we are interested, but he is not the. So here also, the only remedy is under the act. They have to challenge that. And they can only challenge by filing an appeal, which they are not doing. They are repeatedly filing writ petitions. So 45, my lord. Then is the finding, my lord.
Okay, just a minute. Yeah.
Huh.
So, is according to you,
Yes, my lord.
the petitioner obtained this interim order
Yes.
as because
Yes.
they have not annexed those orders?
Those orders.
Okay, why you did not actually? annex?
I will clarify everything, Manoj.
Hmm.
After the submission, I will clarify everything.
My lord.
Point by point, I will clarify.
My lord, what my learned friend is one more I want to show, my lord. He showed a discrepancy in the address, my lord. They are trying to, after the amount was deposited, my lord, they are trying to do. They have filed an FIR also. Kindly have that page, that FIR final report, my lord. That is at page number 90. Just 99. 99. Kindly have 90. Let me finish them. They have given me the. Kindly have 99. So an FIR was filed, my lord. Of the IA, my lord. So once the January 2023, my lord.
It appears so many things involved. And I haven't gone through anything.
Well, that's why
I
that
need
is
to
why
go
Manoj,
through.
it will be the best thing,
I
Manoj.
need to go through the order of this High Court,
Manoj.
even a division bench also.
Yes.
Manoj,
Yeah, in order to understand the entire.
That is the only judgment your lordship has to go through.
If
Because
Manoj-
that reproduce everything. All the previous.
Manoj, if there is some difficulty,
That-
it would be best, Manoj. Justice Surana is coming from the 1st April, Manoj.
This is not done, my lord. Lordship has
Justice
hard to-
Surana has passed the, Manoj, while
is
in
not-
the writ appeal,
they are-
pendency of the writ appeal, we have withdrawn IA, while adjudication under Surana.
This is not done.
We have.
He can't bench hand.
No, it is not bench hunting. They are alleging that.
Because he got it. This is bench. This is, my
We
lord.
have withdrawn the IA.
This is not fair, my lord. I have argued. Lordship has given us a patient hearing, my lord. Lordship has given us a patient. He should
I am
be
not
grateful
complaining.
enough, my lord.
Just a minute, just a minute.
This is not
Have
fair.
anything to submit?
Yes, my lord.
Ah.
My lord, first of all,
Ah.
this entire judgment
Ah.
challenging the quantum
Ah.
of the award was by the union. Now the present petition, the instant petition, is by the beneficiary who themselves, the petitioner themselves claim to be the beneficiary. Those earlier petitions were on the quantum which the union was not agreeing to. That went to so many LA appeal and all. It is a different subject matter. The issue was different. Now the issue is whether these present petitioners are the actual beneficiaries. My learned friend has correctly said that under the Lara Act, on the apportionment, it has to be under section 64. That is also admitted fact. But the present petition is here, this writ petition is saying that the very notification for acquisition itself was not published in the local diaries and two newspapers. So they arouse no occasion to know about this acquisition process. That is the exact allegation in the present petition. The issue is there. The entire proceeding itself was never let known to the petitioners. The notification was not published as required under the statute. Published in two newspapers, in the local diaries and also in the village local language, not circulator. That is the issue here.
That has been decided by the.
That is the issue here. Now, whether that was there, I can see from the records that there is a gazette notification, but whether there is a publication of this notification or not in the newspapers, so that the people who are affected, they have come to know. That instruction, that affidavit will have to file. If there was no publication as required under the statute, the entire process goes.
It can't be, my lord.
No, I'm neither against
because earlier there was a litigation, and then probably that was after that only notification only.
Yes.
And there early litigation, even the division bench also.
Yes.
It appears
There has been litigation. Yes. There has been litigation only with regard between the union, the present applicant here, and the state was a formal party because it was on the quantum, not on the beneficiaries.
No.
On the quantum of the award. The award was the issue there. The quantum of the award, not the ownership of the land. Not the ownership of the land. It was presumed that the present applicant is there since there was no one who came forward. Now this set of petitioners, they have come. They are saying that this entire land acquisition process was never known to them. How come the petitioner, the applicant alone is going to be the beneficiary, whereas he is not from that area? To show that, my lord, to clarify that, we at least need to file an affidavit that this was locally published in the newspaper. It was known to everyone. You cannot come and agitate now. I'm saying to the writ petitioners. Now, if we cannot bring in records, there is no record of newspaper publication as required under the statute. They succeed.
This is the same argument.
That is the fact.
This is the same argument. Before the DB.
That's why in the initial, interestingly, my lord will kindly say.
This will be reopening the entire issue, my lord, division bench.
Now you see, supposing if this interim goes, what remains?
Nothing remains. Nothing remains.
Yes. So now I think they should be given an opportunity to.
That's why I'm submitting this.
My lord.
Page 47 is the first order of the if my lord. Annexure 2, page 47, if my lord. In the page 47. I have to be fair to this honorable court. I'm neither against this present applicant or
This is the same argument, my lord, repeated again and again. Division bench has rejected that.
Anyway, so what we can do
Page
is,
47,
it appears, because if these is allowed, then nothing remains. If
Yes,
nothing
yes.
remains, then entire matter is to be.
Milord, there has to be nothing remain, right? Because the 3 rounds of litigation, Milord, division bench.
So that is
Ha.
why.
So what my learned friend is saying, Milord, 2 things he is saying, Milord. Let me just finish, Milord. Let me just answer. The Lordship asked me a query. Let me answer that. Lordship, he is saying 2 things. One, he is saying whether the procedure has been followed or not, newspaper has been issued or not, whether it is they are not that they are aware of this or not. These are all before this court they cannot agitate because there is a division bench judgment upholding that. So
So
they have to,
in the early litigation, whether the present petitioner was the party?
No,
in any
no,
matter?
no, they were not party. But then-
Okay,
then
okay.
even if they have to,
Yes.
even if they have to challenge it, Milord,
They
have
were
to
not the
fight-
party.
They have to challenge that order by implementing themselves in the Supreme Court.
Okay, but now they have come afresh
Yes.
saying that they were,
No
they
method of
are
protection.
not
So,
aware of
Lordship,
all
tomorrow,
those.
tomorrow, your
Okay,
Lordship.
anyway.
Just one minute. The one logic, Milord. One now. Last hour. I will leave it there. Lordship, tomorrow, your Lordship decides, suppose in my favor.
Hmm.
So can they file another different people? Can they file another writ petition saying they have to challenge that order, your Lordship's order?
Right.
So therefore, Milord,
But
the
now they
division
are
bench
saying that
order.
they were not aware of all these
Yes.
without challenging this.
But that is also misleading.
Now,
Milord.
okay,
That is
yes.
also misleading.
Page 47.
47, my lord, this is the first litigation by the present applicant, my lord.
Hmm.
Page 48,
Hmm.
my lord will see 1, 2, 3, 4, the 4th paragraph.
Page 48.
Yes, my lord.
Para?
The 4th paragraph.
No, page 48,
Yes, this is the judgment.
para 20. Judgment.
Paragraph 4.
No,
This is-
in IA.
IA.
Page 48
48. This is the,
is para 20, 21, 22 only.
my lord, I think that this is annexure 2, my lord. If my lord will see annexure 2.
Annexure to.
Of the writ petition,
Probably.
of the writ petition.
Oh, writ petition, my lord. I'm sorry, my lord. Of the writ petition.
Page 47.
Page 47 of the writ petition, my lord.
Yes. This is
And then the-
writ petition 78.
Yes, my lord. At page 48, my lord.
Ngasimena is present.
Yes.
Applicant.
Yes.
He-
I'm the
Applicant, okay.
yeah. My lord will see, this was by this present applicant, my lord.
Hmm.
In paragraph 4,
Yes.
it is the case of the petitioner, that is of Nasimeta,
Hmm.
that the writ petitioner is the permanent resident of Maline village under Italian circle under Diwan Valley district, and their community land was taken by the ITBP. Here what it says, community land.
Hmm.
This is what he portrayed earlier. Now, at page 52,
Ngasimena 1.
yes, now the entire land becomes his individual land.
I think the entire matter need to be heard.
Yes.
For me. Hmm.
Here, whether that's why
Just me.
he earlier portrayed, came before this honorable court saying that it's a community land, but at the time of acquisition, he claims him to be the sole individual.
And then this, but you see, as submitted by the Rana Council for the applicant, the serial number 2, 3, and 4 already received.
That is another thing. That is in respect of another another place. my lord.
And you know, there is an
Then
inquiry report
my
also.
lord will see at
Okay, this
serial number
yours, this the present case is of Maline.
Malini.
And another
Dambin-
okay, different
Dambin
cases.
Mipi Anile. This is a serial number 1.
Anyway, for me, it appears that it requires the entire matter to be heard.
Yes, we'll have to, our affidavit will be required.
Anyway, so
If
and then this order was passed by Justice Surana, and he would be
From April 1st week.
first way.
Yes.
Lordship may fix a date then.
We'll fix some.
7th April.
this one.
7th April.
Let's pray for by the land council for the parties. Leads this matter during the first week of April. Okay,
Yes.
7th April, ma'am.
7 April.
Second week of April, second week of April.
Second week.
Yes.
Date, you want date? You want particular date?
Yes, Lordship. I will just, can it be, Milord, on 10th, Milord?
Okay, 10th would be
Yes.
Thursday, huh?
Ha.
Okay, 10th April.
Grateful.
God bless.
request for